So this one, I'm gonna close. Whoops.
Morning.
Hi, everybody. Can you hear me?
Yes.
I think I'm supposed to close out something because I have an echo, but I don't know what I'm supposed to close.
Your Honor, I would try closing the live stream feed from another tab.
And where would I find that? I just don't know. I don't know. Now I don't seem to have the echo.
Well, it seems to have fixed itself then.
I love it when that happens. Good. That was not as hard as I thought it was going to be. Hi, Olivia. How are you?
Good morning, Judge Neely. I'm great. How are you?
Good. Where are you?
I'm in Basalt.
All right.
I'm in Basalt.
Let me see. I'm going to rename myself. Oh, hold on. Are you our three scoring panelists then? Jason, Michael, and Olivia?
No, Olivia's
I
our
am
coach.
not. I am coaching.
Okay, good. I have 12 people waiting. Should I just admit all, I guess, or not? I thought I did that.
Yeah, I think you can just admit everybody.
All right. There we go. Wow, we got a whole bunch of people. Look at everyone. Let me see. I think what I'm going to do is want to clean out some of the people who are just observing so that the screen's not so crowded.
And actually, too, observers really should go to the YouTube live replay so that we don't waste bandwidth.
Is that something they should do on their own, Sam, or do I have to?
Yeah, you just go to the homepage and then there's a place to click on the upper bar for the YouTube live stream. And then it's a little misleading because you have to then drop down into the live. It'll first show you the upcoming rounds, but you have to drop down into the live one in order to access it.
And Judge,
That's not something I do. That's something that the participants.
You do. No, any observers should log out of here and go there.
Judge,
Yeah.
I can tell the court we don't have any observers from either of these two teams here today. Just a little bit larger teams, but they'll be turning their videos off so that you'll only be seeing the people who are presenting, and that'll help with what you're seeing, Judge.
That is great. That sounds like Zach Parsons.
It is, Judge.
Good to, I don't see you, but
I would make sure that the scoring judges are there. Din Tuttle, are you on? He was in the orientation, but I don't see him on here.
We'll wait a few moments.
Okay, I'll send him an email and see what,
Okay.
see if I get a response.
This is so unusual, but I think it's also really cool that we can do this remotely. How I wish that we had live people in the courtroom, but sooner than later, I hope.
Judge Neely, it sounds like some of the students from my team are still in the waiting room.
I'm just gonna click admit all again. There we go. One person is waiting.
And that's Mr. Tuttle's now in as well, it looks like.
I'll just keep clicking admit.
Okay, so you've got all of your scoring panelists now. So you're good to go as soon as all the team members are there. Bye.
Well, don't leave yet. I might need help.
I have another scoring sheet.
Okay. I'm not sure how to make certain that we have everybody present. I guess I'm gonna just ask the coaches if we have everybody on your team that needs to be here for purposes of our mock trial. And we'll start with, let's see. Sneffels? No. Yeah, Evans.
Judge, it looks like we have everybody, and I'll just defer to the team to handle it from here. I'm only here in case something comes up, and so I'll be muted from here on out, Judge.
All right, thanks, Coach.
Of course.
So it looks like everyone from Team Evans is here. How about Team Sneffels? Do we know if everyone is here for Team Sneffels? Somebody want to?
Yes, Your Honor, it looks like our team is here and ready to compete. And just like Zach said, I'll be on mute just here in case anybody needs technical assistance.
All right. Well, good morning, everyone. I'm Judge John Neely. I'm going to be presiding over this round. This is the first time I've done this by remote YouTube. I know you guys have, I think, done a couple of rounds already, so you're probably expert at it. So forgive me if I screw up. We usually work with what's called WebEx on the bench through the judicial branch, and it's a little bit of a different program, but I've been on a few Zoom calls, so I am familiar at least with the general operating procedures. If we screw up or if we have any technical difficulties, just chime in and let us know. And I guess there were some problems yesterday, maybe with some bells going off with some kids who are at a school, or people might fall off and lose their connection. We will get through it and we'll just make it work. One of the suggestions we got at our orientation this morning was when you sign in and have your name, for purposes of our scorekeepers, it might be useful for you, if you're going to be a witness, to type in not only your name, but the witness that you're playing. So that makes it easier for our scorekeepers to associate who that actual performer is with the name of the student who's participating and the witness that they are portraying. Let me welcome you all to the mock trial competition. I coached mock trial for a number of years and I'm familiar with the system. And I know how hard you all have been working. We're going to get through this morning just fine. It's going to be fun. I want everybody to be on their game and to do what they need to do, and we'll have a great round, I'm sure. I will ask each side, I'm going to go through the checklist. This is a little bit different from obviously what we would be doing if we were live, but I'm going to start out with, let's see, the prosecution side, which is Team Evans, and I will ask whoever the attorney is who's going to be handling the pretrial procedures if Team Evans is ready to proceed this morning.
Yes, Your Honor.
And who said that?
Hannah Feeney.
Okay, thank you. And whoever is going to be representing and handling the preliminaries this morning for the defense, Team Sneffels, are you ready to proceed?
Yes, Your Honor.
And who is that?
Max Seitel.
All right, thank you, Mr. Seitel. A few preliminary matters before we get started. Normally, we would be asking you to provide the judge and scoring panelists with copies of the roster and the team codes. Do the scoring panelists have the materials they need for the purposes of scoring the round electronically? If so, you can just wave your hand. I think you probably do have all that stuff. Okay, good. Video recording, it's not going to be an issue here because we're doing this remotely. I don't think the Bar Association is going to be taking photographs either because, again, we're doing it remotely. I need to remind anyone who's in the gallery and is connected with the teams not competing in the round that you're not supposed to be here, but I think that's also somewhat changed with the remote nature of our proceedings this morning. I'm going to remind the teams that we don't allow recesses except in cases of emergency. And if you need to take a break during a period of the round where you're performing or something and something happens, just let the court know. And if it's an emergency of that nature, we can stop and accommodate you if we have to. I need to just go through the scoring panelists. And if any of the scoring panelists think that they may have a conflict or some problem scoring this round that could pose a bias for one team or the other, now would be the time to speak up. If you think you're good to go on this, then if I don't hear anything, I'm assuming we're good. All right, I'm going to assume that we don't have any conflicts or anything like that. Reminder to the teams and coaches that any disputes arising out of the competition must be reported in accordance with the competition rules. You must adhere strictly to the timing requirements. I'm assuming we have timers that will give you notification that your time is getting close, and when your time is up, you just need to stop. I will at this time then start with asking each side to introduce the participating team members, attorneys, and witnesses, and we will start with Team Evans, who's representing the prosecution in this case. Team Evans, go ahead.
Yes, Your Honor. Good morning. My name is Hannah Feeney. I will be giving the opening statement, conducting the direct examination of Alex Cifuentes, and the cross-examination of Avery Becker.
Good morning. My name is Anna Carrington. I will be conducting the direct examination of Detective Jordan Markowitz and the cross-examination of Professor Blake Van Owen.
Good morning. My name is Annika Buchin. I will be conducting the direct examination of Kyle Cusack, the cross-examination of Taylor Perkins, as well as presenting the closing argument. May our witnesses please introduce themselves?
Yes, thank you.
Good morning. My name is Grace Oliver, and I am Alex Cifuentes.
Good morning. My name is Kate Malloy, and I am Detective Jordan Markowitz.
Good morning. My name is Pilar Melendez, and I am Kyle Cusack.
All right, thank you all. For Team Sneffels, representing the defense in this case.
Good morning, Your Honor, members of the jury. My name is Max Eitel, and I will be presenting the opening statement for the defense, conducting the cross-examination of Kyle Cusack, and the direct examination of Blake Van Owen.
Good morning, Your Honor. My name is Hayden Clausen, and I will be conducting the cross-examination of Alex Cifuentes and the direct examination of Taylor Perkins.
Good morning, Your Honor. My name is Marcus Winton. I will be conducting the cross-examination of Detective Jordan Markowitz and the direct examination of Ms. Avery Becker. I will also be presenting the closing argument. May our witnesses now introduce themselves?
Yes, please.
Good morning, Your Honor. My name is Brandy Mallender, and I am Taylor Perkins.
Good morning, Your Honor. My name is Paige Flenchy, and I am Blake Van Owen.
Good morning, Your Honor. My name is MJ Mintz, and I am Avery Becker.
All right. Having introduced everyone, I need to put everyone under oath. I'm going to ask all the team members to please raise your right hands.
And Your Honor, there's one student in the waiting room right now. It's a timekeeper.
Hold on. Thank you for letting me know that. I'm gonna, let me see. One person is waiting. How am I going to get them in, I wonder? I see them waiting. Does anybody have an idea how I can get that person admitted? I don't have the option anymore, it seems, to admit everyone.
There may be something where if you hover over their name, it says more or something like that, where you can click on it and then click admit. Since I'm not host, I don't have the ability to help with that.
I seem to be stuck in a chat function here.
If you, in the chat function, if you, in the top left-hand corner, there's a little arrow that's a down arrow.
Close that. Sorry, everybody.
And then if you go to at your bottom, it says participants. And if you click on participants, that should pull up a list of people.
Thanks.
And then if you scroll to the top, admit. I think that'll have it.
How did that do it? I don't see anybody else waiting.
Perfect. I think that took care of it.
Let me just confirm. Do we have all of our timekeepers?
Yes, Your Honor, I'm here now. Thank you.
Yes,
okay.
Your Honor.
I didn't mean to exclude you. It wasn't intentional at all.
Thank
let me
you,
see.
Sorry about
now
that.
I want to go to full screen because I can see everybody better. See, I told you there'd be glitches, probably from my end. All right, let's get back to where we were. All the team members, raise your hands, please. Team members, do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Scoring panelists, do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
Yes.
Thank you. With regard to the gallery members, I don't have any here, but I'm just going to ask you to promise to represent yourselves as positive role models, to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round. Thank you for all of those who are watching remotely. Just keep that in mind. All right. I think that gets through most of our preliminary matters, but let me just ask the attorneys, and we'll start again with the prosecution, if there are any preliminary issues you wish to address with the court before we get started with the trial.
Yes, Your Honor.
Go ahead.
Before we begin, the prosecution would like to verify some of the procedures of this online trial. Specifically, we will be admitting evidence pursuant to Rule 7.4 of the Rules of Competition. As such, evidence displayed on the screen will not be assumed to be shown to the jury unless we specifically ask to publish, and we will only do so when we intend to show an exhibit to the jury after admission. Also, may we have permission to display exhibits on the screen as needed for purposes of admission, or would you like us to ask permission each time?
In the interest of trial efficiency, I have no objection, and I understand the constructive nature of a trial that we're doing today. So if you want to put those exhibits up on the screen and utilize them for purposes of admission, we will assume constructively that the jury has not seen those exhibits until they're actually offered and the court admits them to evidence.
Yes, Your Honor. Also, may we have permission to modify or zoom into exhibits for purposes of clarity?
You may, unless there's any objection from the defense. And I don't hear it.
No objection.
No objection? All right, then you may certainly do that.
Additionally, while all of the attorneys and witnesses have made attempts to be in a space with the best internet capabilities possible, if you are unable to see or hear us at any time, please feel free to interrupt us.
I'll be glad to do that if that's necessary.
And will the jury instructions be constructively read before or after closing argument?
The jury instructions will not be read until after closing.
Then may we reference the jury instruction during our closing argument?
You may, certainly, yes.
At this time, we reserve any remaining time from our closing argument for rebuttal.
All right, thank you. Any preliminary matters from the defense team?
Yes, Your Honor. First, we request that all privileges that have been previously extended to the prosecution be also extended to the defense.
So ordered.
Also, Your Honor, all witnesses may be present for the trial today and may not be sequestered pursuant to Rule of Competition 5.3.1.
That's correct.
At this time, Your Honor, the defense is ready to proceed.
All right, thank you. Having dispensed with the preliminary matters, is the prosecution ready for their opening?
Yes, Your Honor. Before I begin, can you see and hear me all right?
I can see and hear you just fine. It would be helpful for our scorers if you just remind them of your name if they don't already have it on the screen, but with that caveat, I would say you can proceed.
Yes, Your Honor. My name is Hannah Feeney, Feeney. May it please the court?
Thank you.
A mask can't hide the truth, and the truth is in the map, messages, and motive. It was Friday, March 6th, 2020. Mackenzie Brackman, a local defense attorney, was alone in his home on South Flower Street when a masked intruder tried to enter his front door, but it was locked. The Ring doorbell security system was set off. The intruder went around to the back of the residence, and in a panic, the victim grabbed a kitchen knife to defend himself. When the defendant entered through the back door, a struggle quickly ensued over that knife. The defendant wrestled it away from the victim before stabbing him in the back. That's when the defendant ran. The victim tried to follow to the front door before pulling the knife out of his back and rapidly bleeding to death. Mackenzie Brackman died in that home invasion. And that intruder's mask, Avery Becker's mask, can't hide the truth. And the truth is in the map, messages, and motive. After a thorough investigation, we charged Avery Becker with 2 counts: murder in the first degree and second-degree burglary of a dwelling. But to understand murder in the first degree, first we have to talk about second-degree burglary of a dwelling. It says that on or about March 6th, 2020, Avery Becker broke an entrance into or unlawfully entered a dwelling with the intent to commit criminal mischief, which simply means to damage another person's property. Now, let's talk about first-degree murder. The judge will tell you that Avery Becker is guilty of first-degree murder if Mackenzie Brackman was killed by anyone while Avery Becker was committing burglary or in immediate flight from the scene. We will meet our burden and prove the defendant guilty of both charges because a mask can't hide the truth, and the truth is in the map, messages, and motive. Let's break that down. A map. You will hear from Detective Jordan Markowitz, the lead investigator in today's case. She will tell you about call detail records that put the defendant's phone at the victim's house at the time of his murder. You will hear how these phone movements show Miss Becker staying there long enough to commit the crime. Speaking of phones, pay close attention to the messages Avery Becker sent to Alex Cifuentes, a teammate of Miss Becker. She will tell you how this kind of mischief wasn't out of the ordinary for the defendant. After all, she had vandalized the victim's car only days before. You will hear how in these text messages, the defendant confessed to planning to commit this crime just before Mr. Brackman's home was broken into and he was killed. Now, we've talked about map, we've talked about messages. Let's talk about motive. You might be asking yourself, why would a high school student commit such a crime? You will hear how the victim was the defendant's mock trial coach. You will hear all about the bad blood between them and how upset the defendant got when she was kicked off the mock trial team. You will hear from Kyle Kuzak, a crime scene reconstructionist who worked with Detective Markowitz on this case, and she will tell you how the crime scene is consistent with the defendant's motive and how this was a burglary gone wrong, just like what Miss Becker threatened to do in her texts to Miss Cifuentes. But for everything you'll hear today, you won't hear that the defendant intentionally killed the victim, because that's not what happened, and it's not what we charged the defendant with committing. Instead, this was a burglary gone wrong, and Mackenzie Brackman died as a result. That is first-degree murder. A mask can't hide the truth, and the truth is in the map, messages, and motive. After you hear all the evidence, it will be clear that Avery Becker committed this crime, and that is when my co-counsel, Ms. Buchin, will ask you to deliver justice for the victim and find Avery Becker guilty of both charges. Thank you.
Thank you, Ms. Feeney. Defense, ready for opening?
Yes, Your Honor. Before I begin, can you clearly hear and see me?
I can, thank you.
May it please the court?
Thank you. And can you tell me your name again, sir?
My name is Max Seitel.
Thank you very much. Oh, go ahead.
Okay. May it please the court?
Thank you.
There is simply no evidence. The prosecution has no evidence tying Avery Becker to this crime. And because of this, a young woman's future is at stake, and a killer may get away. We can't change the past and bring the victim back to life, but we can bring justice to this case. On March 6, 2020, mock trial coach Mackenzie Brackman was found dead in his home. He had been stabbed and murdered. We agree with the prosecution about these irrefutable facts, but beyond that, the prosecution will tell a story based on a rushed investigation that contains no evidence linking Avery Becker to this crime. But you will hear the truth. You will hear from a close friend of Avery Becker's, Taylor Perkins, about the day before the murder. They were simply playing games on their phones at the local fry shack. Taylor Perkins will tell you that fellow mock trial teammate Alex Cifuentes could have stolen Avery Becker's phone. And then the next day, when Avery Becker realized she was missing her phone, she and Taylor Perkins spent the entire day looking for the phone, not breaking into someone's house. Next, you will hear from private investigator Blake Van Owen about how the prosecution's case was rushed and contains no evidence linking Avery Becker to this crime. Van Owen will go through the specifics of the crime scene, including the stabbing and break-in, proving that the prosecution's crime scene reconstruction was inaccurate. Van Owen will also go through in-depth cell tower data that backs up the alibi provided by Avery Becker. And finally, you will hear from Avery Becker herself about her relationship with her coach, Mackenzie Brackman. You see, Mackenzie Brackman had kicked Becker off the mock trial team, her favorite activity. And all Avery Becker wanted to do was reconcile and get back on the team. She would never commit such a violent crime like the one she's been accused of. All three of these witnesses will discuss one Blair Rollins, another suspect in today's case who was barely looked into by the prosecution. Blair Rollins has a similar build to that of the figure seen in the Ring video cameras. And Rollins also has a clear motive to commit this crime. These witnesses will go through how Alex Cifuentes could have used the help of Blair Rollins to steal Avery Becker's phone and frame her for the murder. But the prosecution did not look down all the alternate routes provided by the actual evidence. I'm asking you today to look for all of the discrepancies in the prosecution's case, to look for all of the holes that were filled with hasty interpretations of a case that contains no evidence linking Avery Becker to this crime. You will see that neither of the prosecution's experts ever mention working with each other in their affidavits, and they even have some contradicting data. Detective Jordan Markowitz accepted unverifying screenshots of possibly fake text messages, and has even brought them into court today. Meanwhile, crime scene reconstructionist Kyle Kuzak lost track of key photos for their investigation. I am sure that by the end of today's case, you will see that the prosecution rushed their case to find an easy conclusion and that it can't be taken seriously in any sense because there is no evidence linking Avery Becker to this crime. Today, the prosecution holds the burden of proof. This means that to pass a guilty verdict, you, the jury, cannot hesitate in your decision that Avery Becker is guilty of murder. But I believe that you are all just and reasonable people, that you will see how the prosecution has no evidence linking Avery Becker to this crime. At the end of today's case, you will not hesitate to call for the innocence of Avery Becker. It is in your hands to make the right decision. Not guilty. Thank you.
Thank you, Mr. Seitel. Is the prosecution ready to call its first witness?
Yes, Your Honor. The prosecution calls Alex Cifuentes to the stand.
Ms. Cifuentes, you've been previously sworn. I remind you that you are under oath.
Yes, Your Honor.
Before we begin, at this time, I ask the court to order the defendant to turn on their camera for the first part of the direct examination for purposes of identification.
Fair enough. Is the defendant there, and can you turn on your camera, please?
Yes, Your Honor.
Thank you.
Before I begin, can Your Honor see and hear me all right?
I can. Thank you for asking.
Good morning. Please introduce yourself to the jury.
Good morning. My name is Alex Cifuentes, and I'm a senior this year at Colorado High School.
How are you feeling about testifying here today, Ms. Cifuentes?
Nervous. I just want justice for my mock trial coach, Mr. Brackman. It's been really hard knowing that he's gone and that I'd have to tell a jury about what Avery did.
Now, we'll get back to that in a second, but could you tell us a little bit about Mr. Brackman?
Well, Mr. Brackman was an incredible attorney and an even better mock trial coach. He seemed to really care about everyone on the team doing their best.
And based on your observations and perceptions, did everyone else on the team have a good relationship with Mr. Brackman?
No, most people liked him, but his relationship with my teammate, Avery Becker, wasn't as great.
How so?
Well, they would argue at almost every single practice. Avery didn't do things the way Coach wanted her to, and Coach called Avery out on it. It was so bad, Avery got kicked off the team twice.
Do you see the defendant here in court today?
Yes, I do.
Could you identify them by an article of clothing and the title of her video?
She's wearing a plain white button-up shirt and a pair of glasses, and the title of her video is D-Becker.
Let the record reflect that the witness has identified the defendant subject to cross-examination.
It will.
Also, at this time, the defendant may turn their camera off. Now, Ms. Cifuentes, you mentioned arguments between Ms. Becker and Mr. Brackman. Were there any such arguments in the days leading up to Mr. Brackman's murder?
Yes, there was actually one 3 days before he was murdered. On that Tuesday, they were arguing about the competition that happened that weekend.
Tell us about that.
Well, Coach was telling Avery that she needed to put in more work before the state competition. And Avery got really upset about this. So upset, she grabbed a Sharpie and stormed outside. Later, I found out she wrote on Mr. Brackman's car.
And how did Mr. Brackman respond?
Well, he kicked Avery off immediately that same night.
And to the best of your knowledge, did Ms. Becker ever attempt to get back on the mock trial team?
She did. She texted me, actually.
Now, I'd like to shift the focus to what happened after Mr. Brackman was murdered. Were you ever asked to come in for an interview by Detective Markowitz?
Yes, I was.
About what specifically?
Well, when the detective first reached out to me, I told her about the text that I had gotten from Avery, and she asked me to come in for an interview.
Did you preserve these texts for Detective Markowitz?
I did. I didn't have my phone with me at the interview, but the detective said it'd be fine to just send her some screenshots of the text.
Let the record reflect that my trial technician is displaying a copy of Exhibit 14.
All right.
Ms. Fuentes, what is this exhibit?
These are the texts that I was just telling you about, the ones from Avery.
Just to clarify, whose texts are in green and whose are in gray?
Oh, well, the ones in green are the ones that I was sending to Avery, and the ones in gray are the ones that she was sending back to me.
And is this a fair and accurate depiction of your conversation with the defendant?
Yes, it is.
Your Honor, at this time, I move to admit Exhibit 14 into evidence.
Is there any objection?
Yes, Your Honor. I have multiple objections. May I proceed?
You may.
My first objection is pursuant to Rule 801 hearsay to both the contact name at the top, Avery Becker, and the texts themselves as they're offered to prove the truth of the matter asserted. My second objection is pursuant to Rule 1003, admissibility of duplicates. Due to this being a screenshot of the text and not the texts themselves, and because the defense has raised a genuine question about the authenticity of these texts pursuant to Rule 901, these are not admissible. And pursuant to Rule 1002, this is not best evidence due to the fact that they are screenshots.
Ms. Feeney, how do you respond?
Yes, Your Honor. This is not hearsay pursuant to Rule 801. The statements in gray made by Ms. Becker are a statement of a party opponent under Rule 801 D2. The contact information at the top, as well as the statements made by Ms. Fuentes, are not being offered for the truth of the matter asserted, but rather to provide context as to Ms. Becker's statements. Furthermore, this is best evidence pursuant to Rule 1002, as it is an original pursuant to Rule 1001D, because electronically stored information, such as texts, an original refers to any printout or other output readable by sight, such as a screenshot, that accurately depicts the information. We can be sure that this accurately depicts the information pursuant to Rule 901B1, as Ms. Fuentes has authenticated this document through testimony of a witness with knowledge. Ms. Fuentes is a witness with knowledge as she was the one to receive these text messages.
Defense, do you want to respond to that?
Yes. Under Rule 801 D2, this cannot fall under the hearsay exception, as the defense knows that Avery Becker simply did not write these messages.
May I respond, Your Honor?
Briefly, sure.
Your Honor, Mr. Fuentes has authenticated that these texts did come from Avery Becker. Any further question into the sender of the gray texts goes to the weight and not admissibility of this evidence and may be questioned upon cross-examination.
All right, let me deal with the hearsay objection first. To the extent that the gray bubbles on these screenshots are purportedly statements by the defendant, those would be statements of a party opponent and they would be admissible under 801. So I'm going to overrule the objection regarding hearsay. I'd like to hear a little bit more argument, though, about the foundational issue regarding the absence of an original. I thought I heard the witness testify that, remind me exactly what the witness said. Are these screenshots from the witness's phone or were these extracted from the phone? Tell me a little bit about that, Ms. Feeney, just briefly, so I understand exactly where these came from.
Yes, Your Honor. These are screenshots taken by Ms. Cifuentes from her phone.
Defense, do you want to respond to that then?
Your Honor, these screenshots were taken from the defendant's phone, but seeing as Detective Markowitz had never examined the phone thoroughly, it cannot be best evidence.
All right. I'm going to let the jury decide what weight they want to give these screenshots. To the extent we have testimony from the witness that these were actually screenshots from the witness's phone, I think that's fair ground for cross-examination, but I'm going to overrule the objection and I will allow the text messages into evidence.
May I publish to the jury?
Yes, thank you.
Now, Ms. Cifuentes, I'd like to draw your attention to the second text from Ms. Becker. What is this text referencing?
Well, this is Avery telling me that she got kicked off the team and asking if I'd be willing to talk to Brackman for her.
And how did the conversation proceed from there?
Well, I told her that I wasn't sure Coach would change his mind, especially after what Avery did to his car. That's when she showed her true colors.
What do you mean?
Well, she was crazy. I mean, you can see she threatens that if Coach is still mad about what Avery did to his car, then he's going to be really upset when he sees what Avery does to his house.
And did Ms. Becker ever explain what she meant by these statements?
Yeah, I mean, I asked her about it, obviously. She said that she was going to wait until Brackman was at work, then break in and trash his house.
Thank you, Your Honor. I have no further questions at this time.
Defense, cross-examination?
Yes, Your Honor. If I may request a moment to reposition my camera and stand.
That's fine.
Thank you. Your Honor, before I begin, can you see and hear me all right?
I can, thank you.
And if any time I cut out, please let me know and the issue will be sorted.
I'll try to do that.
Good morning, Ms. Cifuentes.
Good morning.
Now, from what you saw, Ms. Becker never had to put a lot of effort into mock trial, did she?
No, and she didn't.
But you always put in your best work and your best effort, didn't you?
Well, yeah, I mean, we're not all naturally gifted, so I worked really hard for it.
And it irritated you, didn't it?
Not really. I mean, it's a little discouraging to see someone who doesn't work as hard as you, but she was on my team, so.
So is that a yes or no to my question? Did it irritate you that you had to put in so much work?
Well, it didn't irritate me that I had to put in a lot of work.
And you had a lot of respect for Mr. Brackman, didn't you?
Yeah, like I said, he was an incredible attorney and an even better mock trial coach.
And you proved that respect through your dedication and work. Isn't that right?
Well, yeah, I wasn't going to let all of his effort for mock trial go to waste by not doing anything.
And you believed Miss Becker never gave Mr. Brackman enough respect. Is that correct?
Well, they would argue at almost every practice, and she never put in the work. So, yeah, she didn't respect him that much.
And when Miss Becker got a Best Attorney Award, it felt like a slap in the face. Yes or no?
Yeah, because of all the reasons I just stated of her not working hard.
And she had always gotten the awards that you believed others or even you deserved?
Well, obviously, I think people who work hard should be getting awards over people who are naturally gifted.
And you were excited for the larger roles you could have with her off the team, weren't you?
My senior year, if she hadn't killed Mr. Brackman, yeah, I would have had bigger roles. But we wouldn't have gone to state last year without Avery.
Ms. Cifuentes, I think you misunderstood my question. You were excited for the larger roles that you could have with her gone, yes or no?
No, last year, with her gone, we would have been disqualified from state. I wouldn't have had any role.
Ms. Cifuentes, that's not the question that I'm asking you. What I'm asking you is when you have these larger roles, you got excited because you would have the opportunity to play them well. Is that correct?
I believe I played every role I had well, but like I said, I wouldn't have had a role without Avery there last year.
Moving on, you claim that Miss Becker knew exactly what she was doing when she picked up the permanent marker and vandalized the car. Is that correct?
Yes.
And you believe Mr. Brackman should have pressed criminal charges against Avery for the vandalization of his car?
Well, yeah, she broke the law.
And you say that it was a rightful demotion for Avery to go to the B team. Yes or no?
Yes, like I said, she didn't put in work and effort.
Earlier on, you told the jury that Miss Becker reached out to you about getting back on the mock trial team, correct?
Yes, the text that you saw during my direct.
Your Honor, let the record reflect that my trial technician is currently showing Exhibit 14, which has been previously admitted into evidence.
All right.
Thank you. And you claim that Miss Becker became enraged when she realized that she wasn't going to be let back on the team, right?
Yes, like you can see, she threatens to trash Mr. Brackman's house.
And to be clear, you do not have the original phone that these messages were sent on. Is that correct?
No, by the time that I heard that people thought I faked them, I had already traded in my phone, so I couldn't give it to the police or anyone else.
Thank you, Mr. Hernandez. You may now take down the exhibit. And you never actually gave your phone directly to Detective Markowitz, did you?
No, like I just said, by the time that I heard it was an issue, I had already traded in my phone for a new one.
And in fact, you sent in these screenshots 3 months after the murder of Mr. Brackman, correct?
I don't remember exactly when I sent them in, but I know I sent them in after my interview with Detective Markowitz.
And that is when Detective Markowitz had requested you to turn in these screenshots. Is that correct?
Yes, during my interview with the detective, that's when she asked me to send them.
Thank you, Your Honor. No further questions.
Redirect. Thank you.
First, may I briefly inquire as to how much time is remaining?
You may.
The prosecution has 19 minutes and 30 seconds remaining.
Briefly, Your Honor. Ms. Cifuentes, did you bear any sort of resentment towards Ms. Becker for her mock trial performance?
No, of course not. She was my teammate. And if she succeeded, then we succeeded.
And just to clarify for the jury, did you fake the texts we saw in Exhibit 14?
No, of course not.
Thank you, Your Honor. No further questions.
All right, thank you. The witness, if she'd been on the witness stand, could step down. Does the prosecution have another witness to call?
Yes, Your Honor. The prosecution calls Detective Jordan Markowitz to the stand.
Detective Markowitz, I remind you that you're under oath. You may proceed.
Before I begin, can you see and hear me all right, Your Honor?
I can, thank you.
Good morning. Would you please introduce yourself to the jury?
Good morning. My name is Detective Jordan Markowitz, and I'm a homicide detective with the DPD.
How long have you worked in law enforcement, Detective?
I've been with the DPD for the past 13 years, 7 of which I've been a detective.
Do you have any unique knowledge or skills that you relied on in this investigation?
Yes, in this investigation, I relied heavily on my skills in forensic investigating, specifically in cell phone data.
Do you have any certifications in these fields?
I do. I have a cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement.
And have you used this knowledge and skill in other cases you've investigated?
Yes, all the time. I find myself constantly using this type of expertise, especially given how prevalent cell phones and their data are in today's society.
Your Honor, at this time, I ask that Detective Jordan Markowitz be recognized as an expert in crime scene investigation with an emphasis in the forensic analysis of cell phones and call detail records.
The defense have any objection or voir dire?
The defense has no objection, Your Honor.
The witness will be qualified and may testify as an expert in, did you say crime scene investigation with an emphasis in cell phone technology?
Yes, Your Honor.
All right, you may proceed.
Thank you, Your Honor. How did you become involved in this case, Detective?
I initially received a call requesting a detective at the scene of the crime. So I responded at approximately 2:20 p.m. and I first took note of the fact that the door to the dwelling was open and the victim's body was laying face down just inside the doorway, surrounded by a pool of blood. I also noted a large kitchen knife on the ground near the body.
So what did you do first?
First, I called in a couple of our crime scene investigation teams. Firstly, I called in our forensics team, and then I called in Kyle Kuzak, our crime scene reconstructionist.
Since Ms. Kuzak was the one who reconstructed the scene, we'll talk to her about the specifics of the crime scene. But what was the next step in your investigation?
The next step in my investigation was during the time that the crime was being processed, I received the victim's cell phone. I downloaded the data from the cell phone to see if there would be anything that was pertinent to our investigation.
Did you find anything significant on Mr. Brackman's phone?
Yes, I did. I found 2 pieces of evidence, actually, that were significant.
Could you tell us more about those pieces of evidence?
Of course. The first thing I found is that the victim had a Ring doorbell app installed on his phone. With this app, we were able to download a couple of videos that showed the suspect entering and leaving the dwelling. The second piece of evidence that was significant is that the victim, Mackenzie Brackman, had a lot of recent contact with a mock trial team. So based on that, we had a lead to follow up on.
Let's talk about the doorbell videos first. Did you preserve each of those videos for trial?
Yes, I did.
Your Honor, let the record reflect that my trial technician is displaying exhibits 10 through 13 on the screen.
Record will so reflect.
Do you recognize these exhibits, Detective Markowitz?
I believe I do. However, they are a little small.
Your Honor, may my trial technician have permission to zoom in on these links so that my witness may properly identify them?
If that helps the testimony, I think it will help everyone. So the answer is yes.
So what are these exhibits, Detective?
Yes, these are the videos from the Ring doorbell app that I preserved for trial today.
Are they fair and accurate representations of the Ring doorbell videos?
The links are accurate, yes.
Your Honor, at this time, I move to admit exhibits 10 through 13 into evidence.
Is there any objection from the defense?
Yes, Your Honor. I would object more prejudicial than probative and relevance to these exhibits. The defendant or the suspect in these videos is wearing a disguise. And because the detective not only never searched Ms. Becker's home to determine whether or not she was in possession of such a disguise, so we do not know if Ms. Becker was in possession of such a disguise. This is further irrelevant as it is not in dispute in today's case whether or not there was a break-in into Mr. Brackman's home, but rather whether it was Ms. Becker or not. This evidence does not go to prove or disprove whether or not it was Ms. Becker who broke into Mr. Brackman's home. Therefore, this evidence is irrelevant.
Response from the prosecution?
Yes, Your Honor, these exhibits are not more prejudicial than probative. They help outline how this crime took place, which is extremely relevant in this case, pursuant to Rule 401. There is no prejudicial effect, as they are simply to show the jury how this crime took place, which is incredibly probative.
Your Honor, may I respond?
Yes.
This again goes back to the fact that whether or not there was a break-in into Mr. Brackman's home is not what is in dispute in today's case. What is in dispute in today's case is whether or not it was Miss Becker who broke into Mr. Brackman's home. This evidence does not go to prove nor disprove whether or not it was Miss Becker who did this. Therefore, this evidence is irrelevant and more prejudicial than probative.
All right, let's deal with the relevance objection under Rule 401 first. Evidence is relevant if it has a tendency to make a fact more or less probable than it would be without the evidence. I suspect, not having seen these videos, that it's going to go to the reconstruction of how the actual murder occurred, or the alleged murder, rather than just the breaking and entering component. So if these videos tend to make that issue more clear for the benefit of the jury, I find that it would be relevant. So I'm going to overrule the relevance objection. With regard to the more prejudicial than probative objection, evidence can be excluded on that ground if it's substantially more prejudicial than probative. I haven't heard any argument that this evidence would be substantially more prejudicial, so I'm going to overrule that objection as well, and I will allow the videos into evidence.
Yes, Your Honor.
Thank you. We can take down those exhibits for now and we'll return to them on Ms. Kuzak's testimony. Now, Detective, you also said the phone gave you another lead to follow up on. Could you tell us more about that?
Yes. Like I was saying, the victim, Mackenzie Brackman, had a lot of contact with a mock trial team. So we reached out to a couple of his students. First, we reached out to Alex Cifuentes. And it immediately became clear to me that Ms. Cifuentes had some information that would be incredibly important in today's case. So I asked her to come on down to the station for an interview.
Did you learn anything significant from that interview?
Yes, I did.
What did you learn?
I learned that Ms. Cifuentes had been in contact with the defendant in today's case, and that the defendant had been claiming to want to break into their coach's home and trash it.
Based on this information, what was the next step in your investigation?
The next step in my investigation was evidently to attempt to gain access to Avery Becker's cell phone. Unfortunately, we were informed that she had allegedly lost the phone just days prior to the crime.
So what did you do instead?
We subpoenaed for the defendant's cell phone records, call detail records. We'll call them CDRs for short.
What is a call detail record?
CDRs tell me the location of a cell tower that a person's phone connects to at really any given time when they receive a digital communication, such as a call or a text. And based on that information, I can pinpoint the approximate location of a person's phone.
Using call detail records, were you able to figure out where Avery Becker was at the time of the homicide?
To a reasonable degree, yes. There were actually a couple of maps that were prepared to help the jury visualize what all of this really means.
Your Honor, let the record reflect that my trial technician is displaying exhibits 15 and 16 on the screen.
All right, the record will so reflect.
Do you recognize these exhibits, Detective?
Yes, I do.
What are they?
Exhibit 15 is a map of the CDR data that I collected from Avery Becker's cell phone. And Exhibit 16 is likewise that same map. However, it also has a potential route that the defendant could have taken to get to the victim's home.
Are these fair and accurate representations of the data you collected from Ms. Becker's cell phone?
Yes, they are.
Your Honor, at this time, I move to admit exhibits 15 and 16 into evidence.
Any objection from the defense?
Yes, Your Honor. I would object relevance, more prejudicial than probative, and hearsay. I would object more prejudicial than probative, as because these CDRs do not cannot prove whether or not Ms. Becker was in possession of her phone, and and the defense claims that Ms. Becker was not in possession of her phone. This is substantially more prejudicial than probative, as it only shows where Ms. Becker's phone could have been, and she was not in possession of her phone. This also makes this this evidence irrelevant, as it does not go to prove nor disprove a fact in today's case. As for hearsay, in both 15 and 16, the timestamps as well as the locations and streets are all out-of-court statements being used to prove the truth of the matter asserted. And on Exhibit 16, the dotted line that Detective Markowitz drew is an out-of-court statement being used to prove the truth of the matter asserted. Therefore, it is all hearsay.
Response from the prosecution?
Yes, Your Honor. These exhibits are not substantially more prejudicial than probative. As Avery Becker's location on the day in question is disputed in today's case, these exhibits are probative as they help show where her phone was on the day in question, and in conjunction with that, where she was on the day in question. Therefore, they are relevant pursuant to Rule 401, as they tend to prove where she was on the day in question. As to the hearsay, pursuant to Rule 703, experts may rely on otherwise inadmissible evidence when forming their opinions, and that evidence may be disclosed to the jury if it would help the jury in coming to their conclusion, which these would, as they help prove where Avery Becker was.
What about that dotted line on Exhibit 16?
Yes, Your Honor, that again falls under Rule 703, as it would help the jury understand what route Avery Becker may have taken on the day in question.
Defense, do you want to respond?
Yes, if you give me just one moment to pull up the rules of evidence.
All right.
Your Honor, pursuant to Rule 703, the last sentence of that states that the proponent of the opinion may disclose the opinion to the jury only if the probative value in helping the jury evaluate this evidence substantially outweighs their prejudicial effect. The probative value of this evidence does not substantially outweigh their prejudicial effect, as again, Ms. Becker was not in possession of her phone. Therefore, this evidence does not show where Ms. Becker was, only where Ms. Becker's lost phone could have been. It also does not give an exact location of where her phone was, only the tower that it connected to. This means that the dotted line is not more substantially the probative effect of the dotted line does not substantially outweigh its prejudicial effect.
All right, here's my ruling. I will allow Exhibit 15 in. I don't believe that there's any hearsay on Exhibit 15. These are essentially printouts of maps and cell phone towers. They also are part of the basis of the expert's opinion. I do find that they're certainly relevant because they help explain the expert's opinion with regard to the cell phone data records and the cell towers. With regard to Exhibit 16, it's essentially identical except for the dotted line path that has been drawn by the expert. I will allow Exhibit 16 in, but I'm only going to allow that dotted line in for demonstrative purposes. It's questionable to me whether it actually constitutes a statement, but for example, the expert, if we were in a real courtroom, could potentially stand up and use a magic marker and to explain the expert's testimony, draw the dotted line for the purposes of explaining to the jury the basis of the expert's opinion. That would just be demonstrative. So I will allow it in subject to that limited purpose of the dotted line, and we're going to instruct the jury that the dotted line is purely demonstrative and a basis for further explaining the expert's opinion.
Yes, Your Honor.
Okay.
Yes, Your Honor. Permission to publish Exhibits 15 and 16 to the jury?
You may.
Now, Detective Markowitz, using these exhibits, can you describe for the jury the route that matches both the time and location of the defendant's phone?
Of course. As you can see on Exhibit 16, the defendant's phone begins in the upper quadrant around her home. And then she subsequently travels down and her phone pings the tower between her home and the victim's home once before ultimately she ends up in the bottom quadrant, which is the area that encompasses the victim's home.
So what does all this mean?
To a reasonable degree of scientific certainty, that means that the defendant's phone was at the victim's home for 12 minutes during the time that the crime took place.
Thank you. Exhibits 15 and 16 are no longer needed. Detective Markowitz, in your expert opinion and based on your investigation, was Avery Becker involved in the break-in that led to the death of Mackenzie Brackman?
Yes. In my expert opinion, Avery Becker went to Mackenzie Brackman's home with the intention to break in, and during the course of that break-in, Mackenzie Brackman was killed by Avery Becker.
Thank you, Your Honor. I have no further questions at this time.
Defense cross-examination?
Yes, Your Honor. Allow me one moment while I reposition my camera.
That's fine.
Good morning, Detective Markowitz.
Good morning.
Now, you just talked a lot about all the conclusions you came to in this investigation. Let's talk about the evidence behind those conclusions. There was no DNA evidence found?
No, none besides the victim.
And there were no eyewitnesses that witnessed the crime?
No, however, there was the person who called 911.
So that's a yes to my question. There was nobody that witnessed the crime?
Yes, there were no eyewitnesses.
Now, you claim that the Ring video camera is evidence that Miss Becker broke in.
It is, yes.
However, the suspect in those videos is wearing a disguise.
This is true.
And you don't know if Miss Becker was in possession of such a disguise.
Unfortunately, we were not allowed to investigate Avery Becker further per your orders.
So that's a yes to my question. You did not search Miss Becker's residence?
We were not allowed to.
You weren't able to get a warrant to search her residence?
Again, we were not allowed to.
Now, the video doesn't have a timestamp on it, does it?
No, there are no timestamps.
So you don't know when the video took place, do you?
We know the general time as Avery Becker was at the home from around 1 to 1:12, I believe.
So that's a yes to my question. You do not know exactly when the video was taken.
We know it was during the time that the crime took place.
Now, moving on, let's talk about your investigation. You claim that the biggest break in your case was talking to Alex Fuentes.
That was one piece of evidence that we relied on.
But that was the biggest break in your case, yes or no?
I'm not sure I would say it was the biggest break, but again, it was a piece of evidence that we relied on.
However, you interviewed Avery Becker and Taylor Perkins before you interviewed Alex Fuentes, is that correct?
We were unable to interview Avery Becker.
So it is your statement in court today that you did not interview Avery Becker?
Yes.
You were aware of screenshot texts that you claim were sent by Ms. Becker?
I am aware of the text, yes.
However, you waited a full 3 months after the crime took place for Ms. Fuentes to send you these screenshots?
That is correct. That is when I interviewed Alex Fuentes.
Now, you didn't even ask her to bring her phone in to be analyzed, is that correct?
Ms. Fuentes forgot her phone. I assume it was because she was incredibly nervous. Being interviewed by the police—
Objection, Your Honor, non-responsive. I have asked a properly framed yes or no question, and the witness has gone far outside the scope of this question.
Prosecution?
Yes, Your Honor. Detective Markowitz was just answering this question to the best of her ability. Some questions cannot be answered with a simple yes or no. And Detective Markowitz has not gone far beyond the scope, as she was answering the question, which was you did not ask, which was regarding the Alex Fuentes cell phone.
I'm going to sustain the objection. The witness was offering some assumptions about why the witness, or why the, not the witness who's testifying, but the witness she was interviewing may have done certain things that was beyond the scope of the question. So I'm going to sustain.
I ask that the last part of her answer be stricken from the record.
It will be.
So that's a yes to my question. You did not ask Ms. Cifuentes to bring in her phone to be analyzed.
We asked her, but she did not bring it.
You did not make a further attempt after Ms. Cifuentes, after the initial interview, for her to bring her phone in. Is that correct?
At that time, it wasn't necessary. We already had the text messages.
So you don't actually know if in fact these texts were altered.
We do know that they weren't altered. I wouldn't present untrustworthy evidence.
So you never analyzed Ms. Cifuentes' phone. Is that correct?
It wasn't necessary.
Now let's talk about Blair Rollins. You knew that Blair Rollins was a suspect in this case?
Yes, I was aware of that.
But you never attempted to find Mr. Rollins.
We did attempt to find Blair Rollins at first, but ultimately the evidence didn't lead to Blair Rollins, so we didn't put any unnecessary police work into that.
You never searched Mr. Rollins' residence?
No, again, Blair Rollins was not ultimately a suspect in today's case, so
that's
that
a yes to
wasn't
my
necessary.
question.
I'm sorry, could you re-ask your question?
So that's a yes to my question. You did not search his relevance, yes or no?
No, it wasn't necessary.
Now, let's talk about Ms. Becker's phone. You claim that the phone was at Mr. Brackman's home?
I don't claim, that is what the evidence shows.
But CDR data does not give a pinpoint location of the phone, does it?
No, it does not.
And it does not also tell you whether or not a person was in possession of her phone.
The CDR data alone does not. However, the entirety
So that's a
of
yes to my question.
Objection, Your Honor, cutting off the witness. This is the second time opposing counsel has cut off my witness before she's finished her answer.
Your Honor, may I respond?
Yes.
I was simply redirecting the witness back to my question as she was continuing to answer after she had already answered my question.
Let's move on.
Yes, Your Honor. You claim that Ms. Becker's phone was called by Ms. Perkins several times with no answer?
That's correct.
Meaning Ms. Perkins could have been trying to help Ms. Becker find her phone.
That is a possible theory. However, it's unlikely.
Now, let's talk about Ms. Becker's alibi. You never investigated her alibi, did you?
Ms. Becker did not present an alibi, so no, we didn't investigate it.
It is your statement in today's court that Ms. Becker did not present an alibi?
Again, counsel, you stopped me from interviewing her, so no, she did not present an alibi.
Thank you, Your Honor. No further questions.
Redirect?
May I inquire as to how much time I have remaining first?
Yes.
The prosecution has 10 minutes and 59 seconds remaining.
A brief redirect, Your Honor, and may I have a moment to rearrange my courtroom?
Sir, here, camera.
Yes. Detective Markowitz, opposing counsel asked you a lot about the evidence you have. What evidence do you have that points to Avery Becker being the intruder in this case?
We have the fact that Avery Becker is the same height and build as the suspect in the videos. We have the text messages, and we have the maps.
And how do you know that Avery Becker's phone was in the area besides what you have with the CDR data?
Again, all the facts in the case point to Avery Becker having her cell phone. Therefore, we can know, based on the videos, the cell phone, and the maps, that Avery Becker was at Mr. Brackman's home.
Thank you, Your Honor. I have no further questions.
All right, thank you. The witness can step down. Does the prosecution have another witness?
Yes, Your Honor. The prosecution calls Kyle Kuzak to the stand. And may I have a moment to rearrange my virtual courtroom?
Yes, you may.
And Your Honor, before I begin, can you hear and see me all right?
I can see you just fine. Thank you.
Good morning. Please introduce yourself to the jury.
Good morning. My name is Kyle Kuzak. I am a crime scene reconstructionist for the Denver Police Department. I'm often referred to as a CSR for short.
Now, Ms. Kuzak, a few moments ago, Detective Markowitz established the different roles law enforcement had in this investigation. But what was your role as the crime scene reconstructionist in this case?
As a CSR, my job is to put together all of the forensic evidence to determine how a crime scene happened. For this case specifically, I worked with the forensics team to determine the circumstances in which Mackenzie Brackman's death occurred.
And how long have you been involved in the field of crime scene reconstruction?
For about 19 years now. I have been reconstructing an amplitude of crime scenes, complex crime scenes, involving property crimes, homicides, and burglaries.
And Ms. Kuzak, are you certified to do what you do?
I am. I'm certified under the Colorado Bureau of Investigation.
And without telling us what that expert opinion is, have you reached an expert conclusion in today's case that would be helpful for the jury?
I have, yes.
Your Honor, at this time, I ask that the court recognizes Ms. Kyle Kuzak as an expert in crime scene reconstruction and investigation.
Any objection or voir dire?
No objection, Your Honor.
All right, the witness will be admitted and recognized as an expert in crime scene reconstruction and investigation and may offer expert opinions in that field.
Now, Ms. Kuzak, how did you first approach your crime scene reconstruction in this case?
Every case is different. And as a CSR, my job is to really find a way to come to the most scientifically sound conclusions when reconstructing a crime scene. Therefore, I always follow a 5-step analysis process and document as much as possible in order to reconstruct a crime scene to the best of my abilities.
And what evidence did you rely on to formulate your conclusions?
I looked at all of the photographs that are included in the case file, all 4 of the Ring doorbell security system videos, all of the police reports, and I also looked at the autopsy report and I visited the scene of the homicide.
Ms. Kuzak, based on your 5-step analysis and in your expert opinion, do you have sufficient evidence to properly reconstruct the crime scene and determine what happened to Mackenzie Brackman?
I do.
Let the record reflect my trial technician is displaying what has been previously marked as exhibits 1 through 9, as well as exhibit 18. Ms. Kuzak, do you recognize these exhibits?
I do, yes.
And what are they?
I'll start at the top. From left to right, exhibits 1 through 4 are all photographs of the victim. Exhibit 5 is a photograph of the knife next to the victim. Exhibit 6 is a photograph I took of the knife in the lab setting. And exhibits 7 through 9 are all photographs taken in the victim's residence, specifically the kitchen. And exhibit 18 at the bottom are photographs of the scuff marks found at the rear door.
And do these photographs accurately depict the crime scene that you personally saw?
Yes, they all do.
At this time, I move to admit exhibits 1 through 9, as well as exhibit 18 into evidence.
Is there any objection from the defense?
No objection, Your Honor.
Exhibits 1 through 9 and exhibit 18 will be admitted without objection.
And Your Honor, may I have permission to publish exhibits 1 through 9, as well as exhibit 18 and exhibits 10 through 13, which were admitted in direct examination of Detective Markowitz?
Yes.
So let's start off by talking about exhibits 10 through 12. Let the record reflect my trial technician is displaying exhibit 10. Let's play that first. And now let's play exhibit 11. And finally, Exhibit 12, please. Thank you. You can take those down. Ms. Kuzak, based on those 3 videos, can you explain what we just saw?
Of course. We just saw a perpetrator matching the general height and build of Avery Becker approach the victim's front door, which was locked. Therefore, the perpetrator proceeded to the south side of the residence, opening the back fence gate and proceeding into the backyard. The last video depicts that the perpetrator was opening the sliding glass door and actually entering the victim's residence.
Now let's display for the jury Exhibits 8, 9, and 18. Ms. Kuzak, using these exhibits, what happened after the intruder entered the residence?
The intruder entered the residence through the rear back door, and Mr. Brackman was notified of this through the Ring doorbell security system. Therefore, he armed himself with a knife that came from the knife block pictured in Exhibit 8. So when the perpetrator entered through the rear door, a struggle between the two ensued. Therefore, the scuff marks were left behind at the rear door that show that this struggle occurred. That is pictured in Exhibit 18. And as the struggle occurred, Mr. Brackman came at the defendant in a bear hug, and the defendant reacted by stabbing downward into Mr. Brackman's scapula.
Now let's display Exhibit 13, and at the end of that video, let's display Exhibits 1, 2, and 5. So here's Exhibit 13. And now let's present Exhibits 1, 2, and 5. Ms. Kuzak, using Exhibit 13 and the exhibits in front of you, what happened to Mackenzie Brackman?
As you can see in that last Ring doorbell video, the perpetrator fled the scene immediately, and Mr. Brackman's body was found just inside the front door, as you can see in Exhibit 1 and 2 up on your screen. So based on these 2 photographs and all of the evidence collected on the scene, I came to a reasonable degree of scientific certainty that Mr. Brackman followed the perpetrator to the front door, and he actually pulled the knife out of his own scapula. What is important to understand is that the knife had been acting as a plug. Therefore, when Mr. Brackman removed the knife, it actually nicked his aorta. Therefore, it culminated in rapid and heavy bleeding, which essentially culminated in Mr. Brackman's death mere moments after he removed the knife.
You can take down these exhibits. Finally, Ms. Kuzak, based on your expert opinion, is the evidence you analyzed consistent with Avery Becker committing this crime?
Absolutely. In fact, all of the evidence within the crime scene points to the motive that Detective Markowitz just explained a few moments ago. And all of the evidence strongly correlates Avery Becker to this crime scene.
Thank you, Your Honor. Thank you, Ms. Kuzak. I have no further questions at this time.
Cross-examination?
Yes, Your Honor. May I have a brief moment to rearrange my virtual courtroom?
Yes, you may.
Good morning, Ms. Kuzak.
Good morning.
Let's start with the beginning of the crime. You testify that Mr. Brackman was aware of the intruder?
Yes, through the Ring doorbell security system.
But we don't know if the push notifications on this Ring doorbell security system were turned on or off.
Well, given that the Ring doorbell security system is designed to notify owners if there's any activity outside the home, to a reasonable degree of scientific certainty, we determined that those push notifications would be on.
But we don't even know if he saw this Ring notification.
You're right, counsel. However, based on the context and the reason for why a Ring doorbell system would be installed, we determined that Mr. Brackman did act on those notifications.
But we don't know this because you or no one else in the prosecution investigated into Mr. Brackman's Ring notification system or his cell phone.
My job was to reconstruct the crime scene given the evidence found at the scene.
So to answer my question, you did not investigate Mr. Brackman's cell phone?
No, I don't have the expertise to extract data. I simply looked at the videos for context for what could have occurred within the crime scene.
And a ring notification could have given us a timestamp for when this crime occurred?
Possibly, but not exactly.
But again, you or no one else in the prosecution, for that matter, investigated Mr. Brackman's cell phone.
I'm not aware that the cell phone was specifically looked at. However, I do believe Detective Markowitz mentioned some timestamps of the crime scene.
Moving on, you believe that during this crime, the intruder gained a knife, the murder weapon, from Mr. Brackman in a struggle?
Yes, that is correct.
But you don't have any clear evidence as to this struggle.
No, I do actually. The scuff marks and the open knife drawer and the knife block itself helped me conclude that the perpetrator gained the knife from Mr. Brackman.
Let's talk about those scuff marks. You were never able to date exactly when the scuff marks were made?
That is correct. Unfortunately, we couldn't.
And you were never able to find any clear evidence specifically pointing to how the scuff marks were made?
Yes, we could. The scuff marks themselves.
I think you misunderstood my question. You found no evidence as to what specific action created the scuff marks. You just saw the scuff marks themselves.
The scuff marks would be evidence that a struggle over the knife occurred. They could be from a shoe.
Your Honor, at this time, I would like my trial technician to display Exhibit 17 for purposes of identification.
That's fine.
Ms. Kuzak, you recognize this exhibit, yes?
Yes, I do.
And is this exhibit fair and accurate to the best of your knowledge?
Yes, however, I believe that there are 2 more pages to this exhibit.
Mr. Hernandez, can you please display the rest of the exhibit? Now, can you tell Ms. Kuzak if this exhibit is fair and accurate to the best of your knowledge?
Yes, it is, counsel.
Your Honor, at this time, I move to admit Exhibit 17 into evidence.
Any objection?
No, Your Honor.
Exhibit 17 is admitted without objection.
Mr. Hernandez, can you please return to the first page of this exhibit? Ms. Kuzak, you mentioned 3 different suspects in this exhibit, correct?
That is correct.
But none of these suspects are mentioned in your affidavit.
That is correct. In my affidavit, I simply talk about the reconstruction itself, and any other information was involved in this exhibit.
Let's talk about one of these suspects, Blair Rollins. You don't know where Blair Rollins currently is, correct?
That is correct. That is correct. And to my understanding, she was disregarded as a suspect as there were no leads.
However, you do regard Blair Rollins as a suspect in this affidavit.
Correct, initially. However, she was disregarded as a suspect.
And no one knows where Blair Rollins has been since March 6th, the day of the murder, when Blair Rollins was not at school, correct?
To my understanding, and to the point up until I created this, no.
Moving on, in this document, you mentioned statements from Avery Becker that give, someone say, an alibi to her whereabouts on the day of March 6th, correct?
It is what Avery Becker claims, but yes.
However, during the direct examination of Detective Markowitz claimed that Avery Becker gave no alibi, correct?
I don't think Detective Markowitz was able to talk to her alibi. However, we are aware of what Avery Becker claimed to be her alibi.
So to answer my question, Detective Markowitz claimed that Avery Becker did not give any alibi.
I believe she stated she couldn't talk to her alibi.
Moving on, you have compared the height and size of the defendant to that of the intruder, correct?
No.
In your previous direct examination, I believe that you said Miss Avery Becker had a similar build to that of the intruder seen in the Ring video cameras, correct?
Oh, yes, I misunderstood. Yes, I do conclude she has a general height and build to that of the perpetrator.
Okay. But you have never seen Miss Becker in person and you've never received any photographs of her from the police, correct?
That is correct.
Also, you never factored in the size of the intruder and the size of the defendant into your reconstruction of the stabbing.
Counsel, it wasn't necessary given the context and all of the amplitude of evidence that we have within this crime scene. Therefore, that wasn't a big part of the reconstruction.
So to answer my question, you did not factor in the size of the intruder and the victim into your reconstruction of the stabbing.
I didn't factor it in because it wasn't necessary.
Moving on, there was some blood splatter at the scene, correct?
Yes, there was.
And this blood splatter was necessary for you to complete your reconstruction of the crime scene, correct?
Yes.
And there were some photographs of this blood splatter,
Yes, there were.
but these photographs have been lost.
Yes, they became corrupted, which was unfortunate. However, I was still able to analyze them and review them as I completed my reconstruction.
But the defense expert will not be able to see these photographs.
I am unaware of what the defense expert has been able to analyze.
And the jury will not be able to see these photographs.
Correct. However, given my reconstruction, it was clear that they were telling and that I can interpret the crime scene.
So to answer my question, the jury will not be able to see these photographs.
That is correct.
Thank you, Ms. Kuzak. No further questions.
Redirect?
Before I do that, may I ask how much time I have remaining?
Yes.
The prosecution has 2 minutes and 12 seconds remaining.
With that, Your Honor, I will do a redirect, excuse me. May I have a moment to rearrange my virtual courtroom?
You may.
Now, Ms. Kuzak, you were asked quite a bit about the Ring doorbell system in today's case. How much did the Ring doorbell system help you in understanding the events that occurred?
The Ring doorbell security system videos give context to how the intruder entered the home. However, it does not give context to what happened inside the home. That is why we looked at the broken plate, the open knife drawer, the knife block, the blood splatter, and the scuff marks as well.
And does finding the height and build of the defendant have any pertinence to your investigation in today's case?
No, it doesn't. Once again, given the specific context in this crime scene, it was pretty clear how the events happened or transgressed within the home, especially given the blood splatter and cast off, and as we see, the photographs of Mr. Brackman.
And finally, Ms. Kuzak, why wasn't Blair Rollins a bigger part of your investigation in today's case?
To my understanding, Blair Rollins was disregarded as a suspect simply because her lead didn't lead to any other significant evidence. However, the lead to Alex Cifuentes led directly to Avery Becker, and therefore we can conclude that Avery Becker committed this crime.
Thank you, Your Honor. Thank you, Ms. Kuzak. I have no further questions. And at this time, the prosecution rests.
All right, thank you. Prosecution is rested. Is the defense going to put on a case?
Yes, Your Honor. The defense calls Taylor Perkins to the stand. And if I may request one moment to reposition my camera.
Yes, that's fine. Thank you.
And Your Honor, before I begin, can you see and hear me okay?
I can, thank you.
And if at any point, please feel free to interrupt me.
I will.
Good morning, Ms. Perkins. Please introduce yourself to the jury.
Good morning. My name is Taylor Perkins, and I am best friends with Avery Becker.
And how do you know Miss Becker?
I was on mock trial with Avery.
And how was your experience on the mock trial team overall?
The experience was good at some points, but it wasn't the best. If Coach Brackman didn't like you, didn't always have a great time.
And how do you think Miss Becker did on her performance throughout her seasons?
Avery did incredible every time. Sure, she'd come unprepared sometimes. She did great every single time. She had all the awards to prove it too. But despite all of that, Brackman demoted her to the B team.
And why is that?
A month before the regional tournament, Avery had showed up to practice the most unprepared I've ever seen her in mock trial ever. And afterwards, after we were competing, she had gotten an award or two. And Brackman was furious, going to the point of saying that she didn't even deserve the award, which is really mean. And it was just an unfair moment.
And what did you think about the demotion?
Senior or not, Avery was the best in there. She deserved to be on an A team, and I knew it.
Did you and Miss Becker still hang out after you quit the mock trial team?
Yes, of course. She was still my best friend.
And did anything important happen around the time of Mr. Brackman's murder?
Yes, the day previous, Avery had lost her phone at the Fry Shack.
Objection, Your Honor, may I be heard?
Yes.
Your Honor, I object to lack of personal knowledge. Opposing counsel has not laid foundation as to how the phone was stolen, if it was stolen at all. It's the people's position that Ms. Becker had her phone on the day in question. Opposing counsel has not laid any foundation as to how Ms. Perkins knows the phone was missing, where she was when the phone was missing, and therefore she cannot testify to the fact that the phone was in fact stolen.
You wish to respond?
Yes, Your Honor. I anticipate that my witness will start to lay foundation.
All right, you're going to need to do that.
Yes, Your Honor. And what all had happened that day besides the phone?
Well, Avery had tried to get back into practice, trying to convince Brackman to get back on the team. And when that didn't work, she'd come by my house and we were on our phones playing games and she still had it. And after a while, we decided to go out and we went to the Fry Shack, which I've saw some of the mock trial at that point.
And was there anything out of the ordinary about seeing the mock trial team?
And which day are we talking about currently?
We're currently talking about the day that Miss Becker had lost her phone.
Well, basically, we had seen the mock trial team and we had gotten into a huge discussion about Avery's departure and how sad it was. And everyone was saying how sorry they were and how they'd try to find a way to get her back on. And then Alex had joined the conversation, causing Avery to get upset and then started messing with her phone. And that must have been the last point I'd seen her phone.
And you were an eyewitness to Miss Fuentes playing with Miss Becker's phone, is that right?
Yes, I was.
And since we are on the topic of Miss Fuentes, did you two ever communicate in or out of mock trial?
We wouldn't talk if it was not necessary.
And would you say that you know Miss Fuentes?
I would say yes, I would say I know her.
And is it possible that Miss Fuentes stole Miss Becker's phone that evening after playing on it?
Yes, that is very highly possible.
And what had happened the next day?
The next day, Avery had picked me up. We had a carpooling plan. So I had tried texting her, but I got no response. So when she showed up, I asked her why she didn't respond to me. And we realized her phone was missing at that moment. That's when we went out to search for it.
And how long exactly did it take you to search?
We spent the entire day looking for her phone.
And did you skip school that day?
Yes, we did. We didn't have any tests or anything important, so it was completely fine.
And where exactly did you search for the phone?
We had gone back to the mall in every store we had been the day previous, and I was calling and texting Avery's phone every second I got the chance to hear a sound. Sadly, we never did.
And did you ever find the phone?
No, sadly, we did not.
And do you know anyone who could have killed Mr. Brackman?
Blair Rollins might have actually been involved.
Objection, Your Honor, may be heard.
Yes.
Once again, I raise an objection of speculation as well as lack of personal knowledge and lack of foundation. Opposing counsel has not laid foundation as to how Ms. Perkins knows Blair Rollins. They haven't testified to how Ms. Perkins has a relationship, and therefore Ms. Perkins cannot testify to whether or not it was Blair Rollins who killed Mr. Brackman. Furthermore, testifying that someone killed Mr. Brackman renders under an expert testimony in today's case, and Ms. Perkins is a late witness. This is not rationally based on her own perceptions and observations in today's case. She's not been qualified in police procedure, and she cannot testify to whether someone did or did not kill Mr. Brackman.
You wish to respond?
Yes, Your Honor, but first, may I have a repeat of every rule number that has been objected to?
Prosecution attorney, you've been asked to cite to rules.
I can do that.
All right.
Pursuant to Rule 701, this is not rationally based on her own perceptions and observations. Furthermore, under Rule 702, she's not been qualified as an expert in today's case and cannot testify to who killed Mr. Brackman. And again, with lack of personal knowledge, that is also under Rule 701.
Yes, Your Honor. May I respond now?
Yes, you may.
My question was simply a hypothetical to ask Ms. Perkins if there is any other way that Mr. Brackman could have been murdered. And within this, I anticipate that she will lay foundation later on as to both who Blair Rollins was and how she knew of them.
All right, I'm going to sustain as to foundation. You have to lay foundation for the basis of that opinion. I don't agree that it would require expert qualifications to render an opinion of that nature. A lay person who potentially had direct observations of a homicide would certainly be able to testify based on those observations, but that ties back in with our foundational problem. So I am going, go ahead.
Can we strike any testimonies taken so far by Ms. Perkins until they've laid proper foundation?
Well, I haven't finished my ruling yet. But,
my apologies.
That's all right. As I said, I am going to sustain on the foundation grounds, and until the witness can lay proper foundation for the basis of that opinion, which, as I said, I don't believe would require expertise, I'm going to instruct the jury to disregard the statements that were made until proper foundation has been laid.
Yes, Your Honor.
All right, go ahead.
Ms. Perkins, who exactly is Blair Rollins?
Blair Rollins is a girl from my high school, but I'm not exactly sure where she is now today.
And do you think that most people in your high school would know of Miss Rollins?
Yes, I would say so.
Was Miss Rollins known for anything?
Yes, Blair was known for Brackman's going to court for her dad, and Brackman losing the case, causing Blair to have this horrible hatred for Brackman.
Objection, Your Honor, may be heard.
Yes.
Pursuant to Rule 404A, this is improper character evidence. Opposing counsel is testifying to Blair Rollins being upset about her father, or Mr. Brackman losing her father's case, and therefore is being offered that she acted in accordance with that anger and committed the crime on March 6th.
Response.
Your Honor, we are not offering this for acted in accordance, rather to lay proper foundation as to how Ms. Perkins and others would have known of Blair.
May I respond, Your Honor?
Yes.
I understand that opposing counsel is trying to lay foundation. However, laying the foundation that Ms. Rollins had a vendetta against Mr. Brackman does not serve to help lay foundation, merely to prove that she could have acted in accordance with that anger and committed the crime.
I don't think we've gotten there yet as far as the vendetta issue. And for purposes of this objection, I'm going to assume this would be done at the bench, not in the open presence of the jury. I am going to allow the witness to testify about her knowledge of Rollins. And if and when we get to that point where we get into some character evidence issues, you can renew your objection and I'll make a ruling based at that time.
Yes, Your Honor.
Yes, Your Honor.
Go ahead.
Ms. Parkins, can you please re-explain how many would know of Blair Rollins?
I would say if you took a handful of students from the high school, they would know about the whole case and everything that was going on between Brackman and Blair Rollins. If you asked a handful of 50 people from the high school, they would all give you the same answer, that Blair Rollins would kill a person and not think twice about it.
Your Honor, once again, I re-raise my objection. May I be heard?
Yes.
At this point, opposing counsel and Ms. Perkins have stated that if you asked 50 people, they would all say that she would kill somebody and not think twice about it. That is a character trait, and it is being used to prove that she acted in accordance with that behavior pursuant to Rule 404A. That is inadmissible in today's case.
Response.
No response, Your Honor. We will stop talking about Blair Rollins.
I was going to sustain, so I'm going to sustain the objection. You can move on.
Your Honor, I move to strike any testimony given about Blair Rollins.
So ordered. Well, let me back up. I'm going to strike any testimony about the character trait to which you objected. The other evidence is not objectionable.
Yes, Your Honor. And Ms. Perkins, just as a final say, when you were at the Fry Shack, you did not find Ms. Becker's phone. And when you were at the mall, you did not find the phone either. Is that correct?
Yes, that is correct.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor. May I have a moment to rearrange my virtual courtroom?
Yes.
And Your Honor, can you hear and see me all right?
I can. Thank you for asking.
Now, Ms. Perkins, I'd like to talk to you about a few things you said over direct examination. You stated that it was Alex Cifuentes who could have stolen the phone. Am I remembering that correctly?
Yes, you are.
You prepared an affidavit in today's case?
Yes, I did.
You swore to tell the truth?
I did, yes.
You knew you had up until the day of the trial to update it with any new or relevant information?
Yeah, I did.
And Perkins, you would agree with me that nowhere in your affidavit do you state seeing Ms. Cifuentes holding the defendant's phone. Isn't that right?
That is correct.
In fact, nowhere in your affidavit do you state Alex Cifuentes asking to use the defendant's phone. Isn't that also true?
Yes, that is true.
Now, I'd also like to talk about the fact that you considered yourself an alibi for the defendant in today's case. Ms. Perkins, you've known for around a year now that your best friend, as you stated on direct examination, was being charged with murder. And yet you've never gone to the police telling them that you were with the defendant on the day in question. Isn't that right?
No, that is not correct. I had gone down to the station and spoken with Markowitz, and I had confirmed a lot that day.
That's a very important fact in today's case, and yet nowhere in your affidavit do you state that you went down to the office, to the police station, and talked to Detective Markowitz.
No, I did not, but that is in one of the pieces of evidence in today's case.
That wasn't my question, Ms. Perkins. It's nowhere in your affidavit, yes or no?
Yes, that is correct.
Now, I'd like to talk about the map Detective Markowitz talked about earlier. Let the record reflect my trial technician is displaying what has been previously marked as Exhibit 16. Ms. Perkins, if you look at this exhibit, you can see the defendant's home in the top shaded region.
Yes, I can.
And you can see the victim's home in the bottom shaded region.
Yes.
And you testified earlier today about being at the mall and the Fry Shack with the defendant, yes?
Yes, I did, but at that time, Avery had no possession over her phone.
I understand it's your opinion, but yes or no, that is true?
Yes, that is correct.
And if you look at this exhibit, neither the Fry Shack nor the mall are in any of the red shaded regions.
Yes, that is also correct.
You can take down this exhibit. Now, I'd also like to briefly talk about the text messages Alex Cifuentes talked about earlier. Let the record reflect my trial technician is displaying this exhibit.
It will. There it is.
And Ms. Perkins, you would agree that after the defendant was kicked off the team, the two of you thought of ways to get back on?
Yes, we did together.
And you look at this exhibit, it says Avery Becker's name at the top, correct?
Yes, it does.
And in this text message chain, it asks that Avery is asking for help to get back on the mock trial team, yes or no?
Yes, that is correct.
Thank you, this exhibit is no longer needed. And finally, I'd like to talk about the relationship between Avery Becker and Mr. Brackman to the best of your ability. The two of them had a feud?
Yes, almost every practice.
And the feud bothered the defendant, yes?
Yes, it did at times.
And the defendant even vandalized Mr. Brackman's car days before he was murdered, true?
Yes, that is correct, but at the time, Avery didn't know it to be a permanent marker.
That wasn't my question, yes or no, she vandalized the car.
Yes, she did.
And after which, the defendant tried to get back on the team, as we just established.
Yes, that is correct.
In fact, the defendant tried to get back on the team the day before Mr. Brackman was killed. Yes or no?
Yes, that is correct.
But the victim never changed his mind, did he?
No, he did not.
And just to be clear, he died the next day. Isn't that right?
Yes, he did.
Thank you, Your Honor. I have no further questions.
Thank you. Redirect?
May I inquire about brief time check?
Yes, that's fine.
The defense has 19 minutes and 23 seconds remaining.
A very brief redirect, Your Honor.
Okay.
Now, Ms. Perkins, you knew Avery as a best friend, is that correct?
Yes, I did.
And even though she's your best friend, you're under oath today, aren't you?
Yes, I am.
And you would never lie under oath, would you?
No, I would not.
Avery, although the fact that Mr. Brackman was murdered days after the car vandalization, you do not believe that Avery could have ever made such a rash decision to murder Mr. Brackman.
Objection, Your Honor. May I be heard?
Yes.
Your Honor, opposing counsel just asked a leading question on direct examination, and under the rules of competition, that is not allowed.
It's not allowed under the rules of evidence either. So I'm going to sustain. That was a leading question. You may rephrase.
Yes, Your Honor. Ms. Perkins, do you believe that Avery would ever do something as rash as murder?
No, of course not.
Thank you, Your Honor. No further questions.
All right. Thank you. Does the defense have another witness?
Yes, Your Honor. The defense calls Blake Van Owen to the stand.
All right. You may proceed.
Good morning. Can you please state your name for the jury?
Of course. Good morning. My name is Professor Blake Van Owen.
And as a professor, what do you teach?
I teach police practices and social justice at CU Denver. Before that, I was a faculty member at Community College of the Rockies.
And do you have any professional experience with police practices in social justice?
Of course. I was a police officer for a few months, and after that, I worked as a private investigator along with many other jobs in the police force.
And have you ever been an expert witness before?
Yes, I've testified in over 100 cases.
Can you please elaborate on what you testified as?
Of course. I've testified to police practices, the use of force, cell tower data and cell tower data analysis, crime scene reconstruction, forensic data reconstruction, and many other things.
Your Honor, at this time, I move to admit Professor Blake Van Owen as an expert in general police practices, including forensic evidence techniques, crime scene reconstruction, and cell tower analysis.
Any voir dire or objection?
Your Honor, the people maintain that Professor Van Owen does not have the qualifications needed to opine in these broad fields. However, given the fact that she's been recognized as an expert by other courts, we will not object to her admission as an expert and will instead explore her concerning lack of qualifications on cross-examination.
All right, then the witness will be recognized as an expert in those fields: general police practices, forensic evidence, crime scene investigation, and cell tower analysis or data, and may render expert opinions in those fields subject to cross-examination.
Yes, Your Honor. Professor, can you please explain what the prosecution has claimed took place on March 6th?
Of course. The prosecution claims that Avery Becker broke into Mackenzie Brackman's house, engaged in a brief struggle with the victim, and fled after an accidental killing.
Do you believe that this is what happened?
No, I do not.
How come?
Well, there are 6 main points that I believe exemplify why this is not true. Number 1, the knife block. Number 2, the scuff marks. Number 3, how the knife was held. Number 4, the text messages. Number 5, the cell tower data. And number 6, the lack of other suspects.
Let's talk about your first reason, the knife block. Can you please explain this?
Of course. As we saw earlier, the knife block shown by Kyle Kuzak shows a set of knives that are both wooden and metal. And as we saw in Exhibit 5, the knife that killed Mr. Mackenzie Brackman was entirely metal. This means that that knife did not come from that knife set and must have been brought in by the intruder.
Your Honor, at this time I ask that my trial technician display Exhibits 5 and 8, which have previously been admitted into evidence.
That's fine.
Professor, are these the exhibits you were talking about?
Yes, bloody knife is Exhibit 5.
Can you please describe, using the images, your findings?
Yes, so as you can see here, Exhibit 5 shows a solid metal knife, which is the knife that killed Mackenzie Brackman. And if my trial technician would scroll, in Exhibit 8, we see a set of knives that are both metal and wood, and therefore this knife that killed Mackenzie Brackman did not come from this knife set.
Thank you, Professor. Let's move on to your second problem, the scuff marks on the floor. Can you explain those?
Well, the scuff marks on the floor that Kyle Kuzak claims indicate a struggle, they cannot be dated, which means we don't know how they were made or when they were made, and that means they're unreliable evidence.
Thank you. Now let's move on to your third problem, the way the knife was held and the wound it caused. Your Honor, at this time I would like to display Exhibits 3, 4, 19, and 21. 3 and 4 have been previously admitted into evidence, and 19 and 21 for purposes of identification.
That's fine, go ahead.
Professor, do you recognize these exhibits?
Yes, I do. 3 and 4 are pictures of the wound, 19 is the autopsy report, and 21 is a photo of my hand holding a knife.
And are these fair and accurate to the best of your knowledge?
Yes, they are.
Your Honor, at this time I move for Exhibits 19 and 21 to be admitted into evidence.
Is there any objection?
Your Honor, I have no objection to Exhibit 19. However, I do object hearsay pursuant to Rule 801 on Exhibit 21. Hearsay is defined as a person's written, oral, or nonverbal conduct. This is nonverbal conduct proving the truth of the matter asserted that the knife was held in this fashion.
Response.
Your Honor, this is not hearsay because we are not trying to prove the truth of the matter asserted. We are just trying to give another example as to how the knife could have been held, clarifying Ms. Van Owen's conclusions of the crime scene.
Any response to that?
Yes, Your Honor, that is being offered for the truth of the matter asserted, as they are offering this to show that the knife may have been held in this manner, which is the truth of the matter asserted.
All right, well, based on that response, if it's being offered to show how the knife may have been held, rather than necessarily how it was held, I'm going to overrule the objection I think it goes to weight, not admissibility. I'm not even sure that it constitutes hearsay. I do understand your argument that it is nonverbal assertion, but I think it's explicative of the expert's opinion. And if it will assist the jury in understanding the expert's opinion in that regard, they can decide what weight to give to it. So I'm going to overrule the objection, and I will allow Exhibit 21 in.
Yes, Your Honor.
Yes, Your Honor. Ms. Manon, let's start with Exhibit 4. Can you explain your conclusions based on this exhibit and what it is?
Of course. As you can see in Exhibit 4, the wound given to Mackenzie Brackman is lateral across his chest. That type of wound would be almost impossible to give in a bear hug type motion like Cusack claims, and it would be very hard unless the intruder was significantly larger than the victim.
And how are you able to factor in the size of the intruder and the victim?
Well, considering the amount of force needed to stab through a shoulder blade and into the top of the heart, the victim must either be much larger or have stabbed the victim from behind.
Now let's move on to Exhibit 21. Ms. Manon, can you explain how this was a possibility to how the knife was held?
Of course. If the intruder held the knife in this way, it would give the intruder enough force to puncture through the shoulder blade and into the top of the heart and give Mackenzie Brackman that type of wound.
Thank you, Professor. Thank you, Mr. Hernandez. You can take down the exhibits. Now let's go into your fourth problem, these text messages. Can you explain these?
Of course. The text messages are highly unreliable, given that they are screenshots. Photos can be easily doctored, and the fact that the police did not use their forensic software makes them highly unreliable.
And how could these photos have been doctored in the first place?
Well, Photoshop is an easy option. Additionally, the phone could have been stolen and the text sent from a stolen phone.
Let's move into your fourth problem, or sorry, the fifth problem, the cell tower analysis. Your Honor, at this time, I ask that my trial technician display Exhibit 15, which has previously been admitted into evidence.
That's fine.
Ms. Manon, what is this exhibit?
This exhibit is a diagram made by Detective Markowitz that shows the 3 cell towers that A.B. Becker's phone connected with.
Does this exhibit at all conclude where Ms. Becker was on the day of the murder?
No, it does not. As you can see in the highlighted area, these cell towers cover a very broad range of territory. This means that Avery Becker's phone was in these areas, but not necessarily herself.
And can you explain how phones connect to cell towers?
Yes. Cell phones connect to the cell tower that will give them the best signal, which means that cell towers up to 7 to 8 miles away may receive a phone call if they have the best signal.
And now let's move on to your sixth and final problem, the lack of other witnesses. Were you able to find, or the lack of other suspects, I apologize. Were you able to find any other possible suspects for this case?
Yes, another possible suspect would be Blair Rollins.
Do you have any evidence as to Blair Rollins being a suspect?
Blair Rollins has a much more compelling motive to commit murder than Avery Becker, in my opinion, as well as the fact that they appear to have vanished off the face of the earth.
Do you know the current whereabouts of Blair Rollins?
No, Blair Rollins has vanished.
And was Blair Rollins at school on the day of the murder?
No.
And do the police know where Blair Rollins is currently?
No, they refuse to look into them.
Did the police at all investigate Blair Rollins past the
To
murder?
the fullest extent, no.
Thank you, Professor. No further questions at this time.
Cross-examination.
Yes, Your Honor. May I have a moment to rearrange my virtual courtroom?
You may. Thank you.
Before I begin, can you see and hear me all right, Your Honor?
I can. Thank you.
Now, Professor Van Owen, I'd like to talk to you about something you said on direct examination. You said that the police never investigated Blair Rollins as a suspect. Do I have that right?
No, I said they did not investigate to the fullest extent.
But you have said in the past that Blair Rollins was not investigated by the police?
Yes, I have.
Have you ever said that you relied on the reports made by Detective Markowitz and Kyle Kuzak in order to form your opinions?
I'm sorry, you cut out for a second there. I didn't hear your question.
Have you ever said that you reviewed the reports made by Detective Markowitz and Kyle Kuzak in order to form your opinions?
Yes, I did review the reports.
So surely you noticed that in Kyle Kuzak's report, Blair Rollins is listed as a suspect.
Yes, I did notice that.
Now you say there's no evidence of a struggle at the crime scene. Do I have that right?
Yes, I do.
There were scuff marks found near the door, weren't there?
Undateable ones, but yes.
And there was a broken plate found at the scene?
There was.
And there was a chair found tipped over.
I believe so, but I don't remember correctly.
And based on your analysis, you agree that a burglary occurred, don't you?
Yes, there was a break-in.
And you agree that Mr. Brackman died during the course of that burglary?
Yes, I do.
Now, I'd like to talk to you about some of the things you agree with Ms. Kuzak on. You agree that the description of the blood droplets and cast off is consistent with the victim moving towards the front door with the knife lodged in his back, correct?
Yes, that is consistent, but we don't have the pictures anymore, unfortunately.
That wasn't my question. Yes, it is consistent with that description.
Per description, yes.
And you agree that the victim removing the knife from his back would have caused the cast off?
Most likely, yes.
And you agree that, excuse me, you agree, I'm sorry, you appear to be cutting out. Were you saying something?
No, I appear to be having audio issues. I can't hear you anymore. Your Honor, would it be all right if I turn off my video to see if it gets better?
Yeah, that's fine. And I think with audio issues, we ought to cut the clock so that you're not losing time, anyone's losing time based on a technical issue. Did you hear me? Uh-oh.
Yes, I got that. Thank you. I'm sorry.
Can you hear me now, Professor?
Yes, it's much clearer.
Now, you agree that when that the knife would have been creating a plug in the victim's aorta, is that right?
It would have, yes.
And you agree that when he pulled the knife out, he would have bled to death rapidly?
Yes.
Where we disagree is about who committed this crime. Is that fair?
Yes, that is fair to say.
And you agree that Avery Becker was absent from school on March 6th, 2020, don't you?
Yes, Avery and Taylor Perkins were looking for Avery Becker's phone.
So that's a yes, she was absent from school.
Yes, they both were.
And you agree that the cell tower records place Avery Becker's phone near the home of the victim.
Yes, it's in the area.
And you agree that Avery Becker matches the height and build of the intruder on the Ring doorbell videos.
To some extent.
Now, you make a career out of revealing where the police have dropped the ball. Your words, right?
Yes.
And you think of yourself as a check on the power of police?
I'd like to, yes.
However, you only worked as a police officer for 9 months back in 2005. Isn't that right?
Yes, and my experience was very negative.
And during that time, you never mentioned investigating burglaries or homicides in that role, did you?
No.
And after working as a police officer, you then worked as a school resource officer. Do I have that right?
That was one of my jobs, yes.
And you never mentioned investigating burglaries or homicides in that role either.
As a school resource officer, I'm supposed to be there for the children.
So that's a yes to my question. You never mentioned investigating burglaries or homicides.
No, I did not.
And after working as a school resource officer, you worked as a private security guard.
Yes.
And you never mentioned investigating burglaries or homicides in that role, did you?
Not in that role, no.
Then you moved on to become a professor and a private investigator in 2015. Do I have that right?
Yes.
So you've been an expert in this field for about 6 years?
Yes.
And in that time, you've never testified for the prosecution, only the defense, right?
The prosecution uses their state experts.
So that's a yes to my question.
Yes, it is true.
Now, you would agree that a lot of different law enforcement members were involved in investigating this crime, wouldn't you?
You could say that, yeah.
And with all these law enforcement members combined, probably hundreds of hours were spent investigating this crime.
I would not know.
And in your conclusion, excuse me, in your opinion, when you rush, you miss things, right?
Yes.
And by the way, you charge $225 per hour for research and investigative report and investigations, right?
You cut out for a second. I'm sorry, I couldn't hear you.
You charge $225 per hour for research, report writing, and any investigation work.
Yes.
And you charge $450 per hour for court deposition and testimony, right?
Yes, that is true.
And so far, you've charged the defense just under $7,000.
Yes.
And you plan on charging them another $1,000 for your testimony here today.
That's right, yes.
Your Honor, at this time, I have no further questions for this witness. However, I ask pursuant to Rule 201 that the court take judicial notice that $7,000 divided by $225 per hour is approximately 31.1 hours spent investigating this case.
Any objection to the court taking judicial notice of that math?
No objection, Your Honor.
All right. Then I will take judicial notice of the mathematics that you've just explained. Redirect?
Yes, but before I begin, may I inquire a brief time check, Your Honor?
You may.
The defense has 9 minutes and 55 seconds remaining.
Thank you, Mr. Hernandez. Professor, do you believe that as a police officer and a professor and a school resource officer, that you did gain proper training for investigation techniques?
Yes, during my time working, I spent a lot of time doing police-like activities.
And you have been questioned about the money you make here. Do you do this job for the money, or do you do it for something else?
I do this for the justice system, not for the money.
And finally, you were inquired about only testifying for the defense. Can you explain why you do this?
The prosecution relies on state experts that they don't have to pay. The defense has no access to those state experts.
Thank you, Professor. No further questions at this time, or no further questions.
Okay, thank you. You may step down figuratively. Does the defense have another witness?
Yes, Your Honor. The defense calls Ms. Avery Becker to the stand.
All right, you may proceed.
Allow me one moment to adjust my camera.
That's fine. And for purposes of this testimony, the court will assume that the defendant has waived any right to remain silent.
Before I proceed, can you hear and see me all right, Your Honor?
I can, thank you.
Good morning. Can you please introduce yourself to the jury?
Yes, hello. My name is Avery Becker.
Why are you here today, Ms. Becker?
I'm here today because I'm being accused of murdering my mock trial coach.
Did you commit this crime?
No, I didn't commit this crime. I wouldn't kill him. I feel awful for the things that I've done, but I wouldn't kill him.
We'll come back to that in a moment. Could you tell us about your experience in the mock trial program?
Yes. Last year, I was a senior at Colorado High School. Throughout my time competing for mock trial, I realized that it came pretty easy to me, and I didn't have to try as hard as others.
Did Mr. Brackman agree with you?
No. Brackman made it abundantly clear that he thought I was lazy and did not understand how I could go into practice and know exactly what I was going to say. He hated when I diverted from my script too.
How would you describe your relationship with Mr. Brackman?
It was tense, to say the least.
Let's talk about the car incident that Ms. Fuentes mentioned earlier. Can you tell the jury a little bit about that?
Yes. One practice after regionals, we were going over what we did. I thought that maybe Brackman would congratulate me on my Best Attorney Award, However, he just got on my case about not sticking to my closing and then said that I didn't deserve my award.
How did this make you feel?
I was crushed. I got so mad that I stormed out of practice. When I got outside, I saw his prized possession, his Porsche. So I, with what I thought was a dry erase marker, wrote Worst Attorney Award on it.
What did Mr. Brackman do when he found out?
Brackman blew up at me. He got so mad and then he kicked me off the team.
Objection, Your Honor. May I be heard?
Yes.
This is based on hearsay pursuant to Rule 801 and is substantially more prejudicial than probative pursuant to Rule 403, as well as being improper character evidence pursuant to Rule 404B. The defense is relying on statements made by Mr. Brackman during the car incident, and by using these statements are attempting to prove that Mr. Brackman had a character for anger towards Miss Becker and acted in accordance with that anger to disprove that Miss Becker was an aggressor in the relationship, which is showing that Mr. Brackman acted in accordance with this character trait, which is improper pursuant to Rule 404A. Furthermore, this is substantially more prejudicial than probative, as it characterizes Mr. Brackman as a violent and angry person.
Do you wish to respond?
Yes, Your Honor. As for the character evidence, we are not using this to show act in accordance. This also goes to the hearsay objection, as we're not using this to prove the truth of the matter asserted. We are simply using it to provide context behind why Ms. Becker was kicked off of the mock trial team and to lay foundation for the events that transpired afterwards. We are not using this to show that Mr. Brackman acted in accordance with any character trait or with this specific instance of conduct. We are also not using the statement for the truth of the matter asserted. As for the more prejudicial than probative, the probative value of this evidence showing the jury why Ms. Becker was kicked off the team, it substantially outweighs any risk of prejudice to the jury.
May I respond?
Yes.
Your Honor, if opposing counsel maintains that this is only being used to show context for why Ms. Becker was kicked off the mock trial team, then I maintain that this evidence is not relevant pursuant to Rule 401 because this context is not necessary to the jury to understand why Ms. Becker was kicked off the mock trial team, and just goes to prejudice the jury, making it substantially more prejudicial than probative pursuant to Rule 403.
Let me ask you a question about the hearsay objection. What specifically is the statement to which you are objecting on hearsay grounds?
I am objecting to what Ms. Becker characterized as Mr. Brackman getting very mad and kicking her off the mock trial team, as that is based on a hearsay statement.
Okay, I understand. Anything further from defense counsel?
Yes, Your Honor. As for the relevance objection that opposing counsel brought up, this is extremely relevant, as Ms. Becker being kicked off the team is extremely important to both the prosecution and defense's theory of the case, and it is extremely probative to the jury to understand the context behind that event, so they get a better understanding of all of the events that transpired before Mr. Brackman's death.
All right, thank you both. With regard to the hearsay statement, I'm going to overrule that objection. I think there's been ample testimony from other witnesses that the defendant was in fact kicked off the team as a result of various issues that the alleged victim in the case had regarding her performance on the mock trial team. So I think that statement is independently reliable based on the other testimony that we've heard. I also think that there's a significant issue about the prosecution's admitted motive for the alleged murder based on the fact that the defendant was kicked off the team. So it goes to that. With regard to the 404 issue, generally character evidence is not admissible to prove action in accordance with that character trait, but there is an exception under Rule 404(2), which are exceptions for a defendant or victim in a criminal case. The following exceptions apply in a criminal case, subsection B. A defendant may offer evidence of an alleged victim's pertinent trait, and if the evidence is admitted, the prosecutor may then offer evidence to rebut it, and so on. So I think this falls under an exception under Rule 404(a)(2)(b), where the defendant here is offering evidence of the alleged victim's pertinent trait. And again, that goes directly to motive for the alleged perpetration of the homicide in this case. And the prosecution certainly can pursue that on cross-examination and offer evidence to rebut if they think it's appropriate, but I think it falls under that exception. And that takes care of the relevance objection as well for the reasons I previously stated with regard to motive and so on. So those objections are overruled, and the witness, if she hasn't already answered, and I can't remember if she has, frankly, but if she is going to answer that question, she may. If she's already answered it, the answer may stand.
Yes, Your Honor. Ms. Becker, did you get a chance to finish your answer?
No, I don't believe so. Do you mind re-asking the question?
Yes, absolutely. What happened immediately after you vandalized Mr. Brackman's car?
Well, as I said, when Brackman saw this, he blew up at me. He got so mad and then kicked me off the team.
How did vandalizing Mr. Brackman's car make you feel?
I felt awful. I wasn't thinking about it in the heat of the moment, and it's one of my biggest mistakes that I've ever done.
Did you ever make an attempt to get back on the team?
Yes, of course I did. The next day, I went down to Brackman's office to talk to him. But according to his secretary, he was too busy and not willing to talk to me. So because of this, I had to text him about how sorry I was. I felt awful, but unfortunately, I wasn't able to apologize in person like I wanted to.
Now, moving on, where was your phone on March 6th?
March 6th? I really don't know. I misplaced it.
So where were you on March 6th?
Well, on March 6th, Taylor and I went to the Fry Shack and the mall to go look for my phone. We decided to skip school that day to go look for it. We looked all over the mall, the Fry Shack, anywhere we would have been. We used Taylor's phone to call my phone to see if we could find it, but we couldn't. We finally just assumed that it was either dead or stolen because it kept going to voicemail.
Your Honor, at this time, I ask that my trial technician display Exhibit 14 for the witness.
All right.
Ms. Becker, are these your texts?
No, I never sent any of this. I don't know who's trying to frame me, but these aren't my text messages. I don't know what these are.
Thank you, Mr. Hernandez. You may stop displaying the exhibit. Now, were you at Mr. Brackman's home on March 6th?
No, I don't know where Brackman lives.
And did you kill Mr. Brackman?
Absolutely not. I would never kill Brackman. Brackman and I never had the best of relationships, and I'm not going to try to say that we did, but I wouldn't kill him, and I'm not a killer.
Thank you, Your Honor. No further questions at this time.
Thank you. Cross-examination.
Yes, Your Honor. A moment. Before I begin, may I briefly inquire as to how much time is remaining?
Yes.
The prosecution has 9 minutes and 40 seconds remaining.
And can your honor see and hear me all right?
I can, thank you.
Now, Ms. Becker, I want to talk about some things you said on direct examination. You are regretful of your relationship with Mr. Brackman, correct?
I'm regretful for the things that I've done to Brackman.
Have you ever said that Mr. Brackman had a massive ego?
He at times did have a massive ego.
You even went so far to call him a joke, didn't you?
Yes, because at times it seemed like it.
And just to be clear, you wrote this in your affidavit after Mr. Brackman died, isn't that right?
Yes, that is correct.
As you said on direct examination, you never had the best of relationships, did you?
No, Brackman and I never had a good relationship.
You argued at almost every practice?
Fortunately, yes.
That is, until you were kicked off the team 3 days before Mr. Brackman's murder, wasn't that right? Isn't that right?
Yes, that is correct.
And you were kicked off the team for vandalizing his prized possession with a permanent marker, yes or no?
I didn't know I was holding a permanent marker in my hand at the time, and it was a big mistake of mine.
However, it was a permanent marker, yes or no?
Unfortunately, yes.
And you knew that it was his prized possession, as you said on direct?
Yes, it was.
Now, let's talk about your time in mock trial. You were quite good, weren't you?
Yes, I was.
You knew how to get the judges on your side?
I knew how to compete and do well.
Is that a yes or no to my question?
Yes, that is a yes to your question.
You knew how to tell a story, right?
I knew how to tell the story of the case, yes.
You weren't afraid to lie to get your way, are you?
Objection, character evidence. May I be heard?
Oh, yeah, go ahead. I thought that was your objection. Go ahead.
Your Honor, opposing counsel is offering this testimony against my witness to try and prove that because she was lying and manipulative in mock trial, she could have been during the murder of Mr. Brackman, and this is not permitted under Rule 404.
Response.
Yes, Your Honor. This is proper character evidence pursuant to Rule 608, as it is going into the truthfulness of the witness, as well as it is proper cross-examination into the quality and credibility of the witness pursuant to Rule 611.
Do you wish to respond?
Your Honor, again, this is not going to the truthfulness of the witness, as this was in a mock trial setting rather than in her day-to-day life. Therefore, it has no bearing on what she was actually like outside of mock trial.
You want to respond to that?
Yes, Your Honor. The weight that the jury assigns this evidence this goes to the weight and not admissibility of this evidence, because this is going into the truthfulness or untruthfulness in this case of Ms. Becker, which is permissible pursuant to Rule 608, and it is proper cross-examination into the quality and credibility of the witness pursuant to Rule 611.
Well, with regard to Rule 608, a witness's character for truthfulness or untruthfulness is proper ground for inquiry in the form of a reputation or opinion for truthfulness. You're asking the witness directly about whether she's truthful or not, and it sounds to me like you're drawing that inquiry based on specific instances of conduct under 608B. It's a little bit of an unusual approach, because normally you would be getting that opinion or reputation evidence from another witness. But in the context of cross-examination, I will allow it. I think it is proper cross and the witness can respond appropriately. So the objection's overruled.
Yes, Your Honor.
So, Ms. Becker, you aren't afraid to lie to get your way, are you?
When I was competing for mock trial, I spoke the facts of the case.
Let's talk a little outside of mock trial then. You lied to your mother the night you were kicked off the team, correct?
I did not mention on why I was kicked off the team other than the fact that Brackman blew up at me. So I guess so.
And you told her that Mr. Brackman got onto you for no good reason. Am I correct?
Well, he did start to get on me before I stormed out of practice for no good reason.
However, after the vandalization of his car, you knew that wasn't true, didn't you?
I don't understand your question. Can you please re-ask it?
Of course. Following the vandalization of his car, you knew that Mr. Brackman wasn't, quote, getting on you for no good reason. Am I correct?
I guess so, yes.
Now, let's talk about where you supposedly were on March 6, 2020. You agree with the prosecution that you skipped school on March 6th, correct?
Yes, that is correct. Taylor and I did.
And we can also agree that you and Ms. Perkins are best friends?
Yes, Taylor and I are very good friends.
Of all the people who supposedly saw you at the mall, Ms. Perkins is the only one testifying that you were in fact at the mall that day, isn't that right?
Well, I was with Taylor Perkins for most of the day, so yes.
And Ms. Perkins is also the only one testifying that you lost your phone the day before, isn't that right?
Yes, that is correct.
At this time, may I publish Exhibit 14 to the jury?
Yes.
Now, as you stated on direct examination, you did try to get back on the mock trial team, correct?
Yes, but to do that, I went down to Brackman's office.
However, that's a yes to my question, isn't it?
Yes, that is.
And that is your name in the contact information at the top of the screen, yes or no?
Yes, that is.
Can we agree that you were asking for help to get back on the mock trial team in these texts?
In the text messages, it says that Avery Becker is asking to get back on the team, yes, but I never sent these.
However, the person labeled as Avery Becker asks for help to get back on the team. Isn't that right?
That is correct, yes.
Thank you. The exhibit is no longer needed. We can agree that you match the general height and build of the person in the Ring doorbell cameras, correct?
For the most part, yes.
And at this time, may I publish Exhibit 16 to the jury?
Yes.
So, and you heard Detective Markowitz testify earlier that this was where your phone was on March 6th, correct?
Yes, I did hear that, but I lost my phone, so I don't know where it would be.
However, if you look at the top of the screen, your house is within the red shaded region where your phone was at 12:47. Am I correct?
Yes, that is what it shows.
Thank you. The exhibit is no longer needed. And at this time, I have no further questions.
Redirect of the witness?
Briefly, Your Honor.
Thank you.
Ms. Becker, do you get along with every person you meet and come across?
No, as a human being, we like and dislike some people. So Brackman was one of the people I disliked.
Does this mean that you kill every person you don't get along with?
No, I haven't killed anyone.
Finally, could you describe to the jury why you and Mr. Brackman didn't get along?
Brackman and I never got along because we just had different ideas of what to do. And I wanted to do it my way and he wanted to do it his way. So because of this, we did not like each other.
Thank you, Your Honor. No further questions.
Does the defense have any other witnesses they intend to call?
No, Your Honor, the defense rests.
All right. That concludes the presentation of the evidence in this case. At this time, we will then proceed to closing argument. I'll ask if the prosecution is ready to proceed with closing.
Yes, Your Honor. However, before I begin, I have two requests.
Go ahead.
My first request, as a reminder, is that during pre-trial, my co-counsel asked to reserve any time left in my closing argument for rebuttal. And so I ask again that any time remaining at the end of my closing argument be left for me to use in my rebuttal.
All right, that's correct. And you may use whatever time you have left for that purpose.
And Your Honor, my second request is that during the course of my closing argument, my trial technician be allowed to display pieces of evidence I'll be discussing that have already been admitted into evidence and that we've already sought to publish. In particular, I'll be discussing Exhibit 16 and Exhibit 14, and I ask permission for those to be displayed to the jury during the course of my closing argument. And I also ask that jury instruction 7, 8, and 9 also be displayed for the jury, as I'll be discussing those as well.
Those are all proper requests, and I have no objection, and I will extend the same privileges to the defense when they do their closing if they wish to use any exhibits or make specific reference to jury instructions that will be later read to the jury.
Thank you, Your Honor. May it please the court.
That's fine. Go ahead.
You can hide your face behind a mask, but you cannot hide the truth. And the truth is in the map, the messages, and the motive. The prosecution and defense agree on a lot today. We all agree that a burglary happened. We all agree that during said burglary, Mackenzie Brackman was killed. And we all agree that a person wearing a mask and matching the size and build of the defendant is the one who committed these crimes. The only dispute here today is over who wore that mask. But members of the jury, that mask cannot hide the truth because the truth is in the map, the messages, and the motive. The map. Detective Markowitz showed you with Exhibit 16 the route taken from Avery Becker's house to the home of the victim. The detective explained how cell towers tracked Avery Becker's route, placing her at the scene of the crime during the burglary and murder. The messages. You saw the text messages sent from Avery Becker to Alex Cifuentes. Texts that were exposing Avery Becker's bitter intent. Let's hear those texts again. Well, if he's still upset about what I did to his car, then he's going to be really upset when he sees what I do to his house. I'm going to wait till he's at work, then break in and trash it. That'll show him. And that's exactly what Avery Becker did. She waited until she thought Mr. Brackman was at work, broke in with the intent to do damage, and then stabbed Mr. Brackman with the very knife he used to defend himself. The motive. As we heard time and time again today, Avery Becker and Mr. Brackman have had a history of petty fights and low blows, escalating in the vandalization of his 1986 Porsche. Failed attempt after failed attempt to get herself back on the team made Avery Becker angrier than she had ever been before. So she put on the one thing she thought would hide herself, a mask, and made a promise that she would get back at Brackman if it's the last thing she did. Now, as the prosecution, we've charged the defendant with 2 charges: murder in the first degree and second-degree burglary. But in order to understand murder in the first degree, it's helpful to talk about second-degree burglary. So let's do that. Jury instruction 8, which is displayed for you now, defines the crime of second-degree burglary. And jury instruction 9 defines the crime of criminal mischief, the very crime the defendant intended to commit during the course of the burglary. Now, when you put it all together, we've proved the defendant is guilty of second-degree burglary simply because she entered Mr. Brackman's house without permission and with the intent to do damage to his property. Remember, it doesn't matter whether the crime of criminal mischief was committed. The defendant was guilty of second-degree burglary the moment she stepped into Mr. Brackman's house. So now let's talk about murder. Jury instruction 7 indicates the elements of murder in the first degree. It says Avery Becker committed this crime if Mr. Brackman was killed in the course of the burglary. Members of the jury, the defense's own theory is that Mackenzie Brackman died as a result on the home invasion on March 6th. The only question left for you is over who wore that mask. We've answered that question for you. You know it was Avery Becker behind that mask because we showed you the map. We showed you the motive, and we showed you the messages. Find the defendant, Avery Becker, guilty. Thank you.
All right, thank you. Defense closing?
Yes, Your Honor. There is no evidence. The prosecution has put a young girl on trial for murder without bringing a single piece of evidence tying her to this crime. The prosecution wants you to find Avery Becker guilty without meeting their burden. Let's talk about what that burden is. The prosecution had the burden of proof in today's case. They had to prove beyond a reasonable doubt that Miss Becker committed second-degree burglary of a dwelling and first-degree murder. Second-degree burglary of a dwelling is defined as Miss Becker, on or about March 6th, unlawfully entered and remained in Mr. Brackman's home. The second count, murder in the first degree, states that while Miss Becker was in Mr. Brackman's home, Mr. Brackman died. They had to prove both of these counts beyond a reasonable doubt. What is a reasonable doubt? Reasonable doubt is such a doubt that would cause reasonable people to hesitate in matters of importance to themselves. A mere hesitation is all that is required for you to give the verdict of not guilty. After all that you have heard in today's case, you should have much more than just a mere hesitation. Let's talk about the evidence you heard, or the lack of evidence. You heard all about Detective Markowitz's failed investigation. You heard them talk about how they did not investigate Miss Becker's alibi. You also heard Miss Kuzak testify that they knew about Miss Becker's alibi, but Detective Markowitz chose not to investigate. You heard them say there was no DNA, no fingerprints, and no eyewitnesses. So what evidence do they think they have? A video and a cell phone, neither of which can be tied directly to Miss Becker. The video that they claim as evidence only shows a disguised intruder entering through the back door of Mr. Brackman's home. Miss Becker was not in possession of such a disguise. Then there was the phone. The prosecution claims that because Miss Becker's phone was at the scene of the crime, that Miss Becker must have been there too. However, you heard Miss Becker tell you she lost her phone the day before. But yet again, Detective Markowitz didn't bother looking into that fact. This is not the end of Detective Markowitz's unfinished investigation, as instead of trying to get Miss Cifuentes to bring her phone into the station to be analyzed, she simply accepted unverifiable screenshots 3 months after the crime took place. Now, let's talk about Kyle Kuzak and their interpretation of the evidence. They claim that after being alerted by his Ring surveillance system, Mr. Brackman grabbed a kitchen knife, and through the subsequent struggle, the intruder took possession of this knife and stabbed Mr. Brackman. They think they can get all of that from scuff marks on the floor, an open knife drawer, and a broken plate. Now, you heard Professor Van Owen tell you all about the evidence and what it actually shows. Professor Van Owen explained to you how there is no reliable evidence of a struggle. She told you that because Detective Markowitz never thoroughly searched Mr. Brackman's phone, we don't even know if he had notifications on. After all that you have heard in today's case, there is no possible way that you could give the verdict of guilty. You cannot be sure beyond a reasonable doubt because the prosecution brought forward no evidence proving Ms. Becker was even at Mr. Brackman's home. So because the prosecution failed.
Time, sorry.
Okay, thank you.
You can say thank you.
Thank you.
You're welcome. Do we have rebuttal?
Yes, Your Honor. Before I begin, may I inquire as to how much time I have remaining?
Yes.
You have 1 minute and 5 seconds remaining.
Now, opposing counsel throughout their testimony today, throughout opening, throughout closing, said that the prosecution conducted a failed investigation, a flawed investigation, a rushed investigation, that we didn't bring any evidence. I'll have you know that the prosecution submitted 17 pieces of evidence in today's case. If there's no evidence, as the opposing counsel claims, then why did we spend the last 2 hours displaying fact after fact to the members of the jury that it was Avery Becker who committed this crime? So look past what opposing counsel is saying. The only reason that they're saying that there is no evidence is because they can't accept the truth. They can't accept the truth that's in the map. They can't accept the truth that's in the messages, and they can't accept the truth that's in the motive. Find the defendant Avery Becker guilty. Thank you.
All right, that concludes closing arguments, and that is a wrap up of the case. Thank you, everyone. I'm going to suggest that our scoring judges complete their score sheets, and when they have completed those score sheets, we can log back in, or we can activate our video and audio, and we can go through some teardown and a little bit of feedback. I'm going to ask that everybody who's going to make comments, keep those comments brief, 3 minutes or so. I know we've got another round coming up, and I imagine these young folks would like to get some lunch and meet with their coaches. So when you've completed your score sheets, just let me know and we'll log back in, or you guys can unmute and give the participants some feedback. And I see a request. The plaintiff's team code again was Evans, as in Mount Evans, and the defense team code was Sneffels, as in Mount Sneffels. Well, that was fast. I got a notification from Judge Timbreza that he has all the score sheets and we're good to go. I'll start out and I'll keep my remarks pretty quick here. It's good to see you all again. I don't know, everybody can turn on their video if they want. We can see you all. I remember most of you from other rounds that I've judged in previous years. Good to see you all again. You guys all did a great job. Very nice performance. It was a clean round. There were good evidentiary objections. Not to say that it can't be improved, because there's always room for improvement, but you guys just get better and better every time I see you. That's a credit to your coaches. I want to talk not so much in specifics, but I want to talk about a few of the evidentiary issues. The texts, obviously, I think those are going to come in every case. I think they're pretty important documents. I will tell you that there are more stringent rules if you were in a real case for actually getting those texts into evidence. I would suggest when you are the plaintiff's side and you're trying to get those in, I don't think it would hurt to have your witness testify a little bit about the context of those texts and just say, that's Alex's name on the top. I recognize that. And the whole context of the text communications are consistent with what was going on at the time. So it fits in the time and place. The problem is that you don't have a phone number associated with that. And it's just sketchy, but I think they're going to come in and it's really fruitful ground for cross-examination about whether those texts could have been fabricated. Obviously, that's something that the defense is going to hammer pretty hard. That's my one comment on those. There was a little bit of a struggle, I thought, with regard to the direct examination about Rollins and Rollins' anger about what happened with his dad and why he might be a potential suspect. And the way that was coming in was puzzling to me. You know, there were, if you asked 50 kids at the school about, you know, that issue, they would have told you that he was angry about it. That sounds like reputation evidence that you might be wanting to get in with regard to truthfulness. I don't think it really fits here. I think a much cleaner way of doing that, you know, 404 has an exception for evidence that relates to motive. So I would just go right to that evidence issue and say, hey, you know, we're aware that the defense is arguing that Rollins is a potential alternate suspect. What motive would he or she have for killing the coach? And you'd say, well, I'm aware of this prior criminal case and the coach botched the criminal case and the dad's all ticked off, and that would be a motive right there. So I think you can get around that 404 evidence very much easier just by going to 404 on the motive side, which is a very clear exception for letting in character evidence if it goes to somebody's motive. That to me would be a little quicker. The request for me to take judicial notice of the hourly rate and the number of hours put in on the case, I wouldn't ask the judge to take judicial notice. Just, God, tear that expert apart. You know, they can do that just as easily. You can say, you billed this amount of time, and if I do the math right, you've only spent 33 hours on this case. Isn't that right? It just looks a lot better because you're attacking that witness directly on the lack of preparation or the lack of time that's in there. A couple of things I wanted to point out. Just remember, when you do your objections, it's always good practice to cite to the rules. I did have one objection where opposing counsel said, can you tell the other attorney to go ahead and cite the rules? That was okay. I sent it back to that person and said, go ahead and cite the rules, but that wouldn't have been an issue if you just remembered right at the start saying, Your Honor, I'm objecting pursuant to. You should always start that objection in that manner. There was an issue that finally got pulled out for me at the very end on the defense closing about the actual burden in a criminal case being beyond a reasonable doubt. I think that should have come out maybe even in openings. I've seen really good prosecutors say to the jury, you know, our burden today is to prove our case beyond a reasonable doubt. We are happy to accept that burden and we're confident that we're going to meet it. And here's why. I think that should have come out sooner. I think it was really good for the defense to hit on that on closing. A comment on the closing by the defense about there is no evidence. Actually, there is a lot of evidence in this case. The problem is that it may not be conclusive evidence and it may not be sufficient to meet that burden. I would stay away from that. There is no evidence, because there really is. I mean, and on the rebuttal, that was brought out by the prosecution pretty accurately, saying we just spent 2 hours going through the evidence. So it's not that there's no evidence, it's just that the evidence may not be sufficient to actually tie the defendant to the crime. Those are just a few highlights. I wish I was here, as I said, in person with all of you. I thought the poise and demeanor that everybody showed in the case, I didn't see a lot of nervousness. I didn't see a lot of fidgeting. A few couple of you might have had some awkward hand gestures, but I think it might be easier for you because we are doing this remotely. When we get back in the courtroom and you're in front of a live panel and you're standing up in a room full of people, I know it's going to be harder. But I thought your overall demeanors, I thought everybody handled themselves very professionally, and I think it was a really good round. You guys are both very good teams. As I said, I've seen you before, and the work that you've put into it was evident. So good job. Good job to you. And I guess I'll turn it over to our scoring panelists to make any more specific comments they think they want to make. And I don't have any particular order. I see Mr. Wilmore up there, and if you want to go first, that's just because you're there.
Sure, I can go first. So my name is Michael Wilmore. I'm a primarily criminal defense attorney. Was in the public defender's office in Grand Junction for about 3 years, and I've been in private practice with a law firm called Calamia Gosha, primarily in Pitkin County, Aspen, and Glenwood for about a year now. I did mock trial briefly in law school. First, I mean, I think you all did a very awesome job presentation wise, and I'll say that your Zoom skills are probably better than about 98% of attorneys who are practicing right now. And I see Judge Neely nodding. I'm sure he's had issues coming up, but that was very smooth, and I thought you guys did a really good job handling that. Just a few general points of feedback for everyone. From well, first of all, when you're making like objections, I think a few times the first objection you started with was a 403 objection, so it's more prejudicial than probative. I would always save that one for the end because it's kind of like your last resort. And if you're starting with that, I think in general, a judge will know that your objection's probably not going to go anywhere unless it's like extreme, but that's like a super ticky-tacky thing. In more general terms, when you're crossing witnesses, it's super easy in mock trial, no matter what level you're at or whether you're an attorney, to like get locked in on your script. But listen to what the witness is giving you, because some of the witnesses gave you some gold that you could have followed up on. So like 2 examples I thought of real quick were the detective testified. One of the defense attorney asked her, like, you didn't get a warrant to search the house. And then she was like, I wasn't allowed to. And it was going along like a path, basically saying that the defense team had shut that stuff down, but she could always go get a warrant. Like, that's a court order. She could go search the house. Or like the other expert, like you were trying to get her on the size of the intruder and like the height and differences of that. And she was saying it's not pertinent. Are you like, you're telling me in a murder case that the size of the person who did the murdering isn't important? So like you could like blow up that kind of stuff. And on direct, when you're directing your experts, I thought your witnesses did a great job of acting like experts. They get very technical with things. So like talking about the scapula and the aorta and stuff. And in real trials, jurors can oftentimes ask questions. And I could see a juror question being like, what's the scapula? What's the aorta? So asking that follow-up, like, what is this, can really like put you above and beyond and really show like, hey, I'm relating to like the jury. Like, you know, you kind of put yourself in the mindset of like a juror and be like, you said scapula, like, where is that on the body? And you could have your witness like point it out. And I think that stuff could really take you above and beyond. But yeah, overall, you all did a great job. It was awesome to watch.
Well, one of our other panelists.
This is Din Tuttle. I'll chip in. Can you hear me?
Yes, thank you.
Okay. I was amazed. I think you all did an amazing job. I've been on the bench for a long time, mostly in this country, and I wish you all had been in my courtroom more often than many who I had. No, you did a great job. Your demeanor, but everything was, you were so prepared, which is wonderful. But just to follow up on what my fellow scorer just said, visuals with your actions, your gestures, that type of thing is something that is helpful if it's real. I mean, just even a few things just to highlight what you're showing, and I don't know, stabbing in the back, that that kind of thing. If you can do it right, whichever way it's going to help your case, jurors are going to remember that. They're not going to just remember hearing things. But I don't have anything to say other than I'm amazed. I've judged other mock trials around the state too. I'm from Northern Colorado, so I'm not usually with you all. And I'm really, really impressed. And if you all want to be lawyers, go for it. Go for it. Good job.
Mr. Bailey.
Hi there. My name is Jason Bailey. I'm actually an attorney in Alabama. I used to live in Grand Junction, but I left there about 5-6 years ago. And Judge Tim Braza roped me into this. I'm very happy that he did. I've done this a number of years ago. So the last one was at least 5 years ago. And I was just really impressed today that the quality of both teams was at least as good as anything that I saw in the previous tournaments, the Western Slope tournaments before. So congratulations on that. I don't have the same trial experience that any of the other judges do, or the judge does, obviously. So I can't help but merely repeat what they've had to say, which is really the hardest thing I always think is to listen to what the witnesses are giving you, because they do give you a lot, as Mr. Wilmore was saying. And to the extent that you can use that and turn it around and emphasize those points that you made in your opening and that you're going to make in your closing, it just really helps, because jurors, and I include myself, always have trouble listening. And the more you can hone them back in and get them back to your main points, the better for you. But I would encourage you all to consider careers in the law. It's extremely rewarding and well worth your effort. And congratulations, you all did very, very well.
All right, good comments. So I wish you all luck in the next round. I know that you guys need to take a break, so we will let you go. And I hope that some of you or all of you or some of your teammates get to go on to the state tournament. And I will reiterate that I thought the Zoom, I was terrified about doing the Zoom today because I haven't really used it that much, but you guys must be an age thing, because you were so fluid and your technicians were really great on getting the exhibits pulled up, and it made my morning a lot less stressful. So good work to you all. Congratulations. And it's great to see you all again. And I look forward to hearing what the final results are. But we'll go ahead and log off and let you guys get back to your coaches and well, I guess you're not with your coaches. Go have some lunch and have a great round at 1 o'clock.
Thank you.
All right, bye.